Our first case is on page 9, Inspector Evan Oakes. Case number CE 21060328, case address 1701 Northwest 18th Court. Owner Peaceful Zion Missionary Baptist Church of Fort Lauderdale, Inc. Property posted 8/13/21, posted at City Hall 9/16/21.
Good morning, Your Honor.
Good morning.
Code Compliance Officer Evan Oakes, City of Fort Lauderdale Community Enhancement, presenting case number CE 21060328, property address 1701 Northwest 8th Court. This property was initially inspected on June 10th, 2021, and the following violations were observed. 9-306, the exterior building walls have not been maintained. Structural parts, including fascia and soffits, are in disrepair. There are areas of the exterior that have stains and missing peeling paint. The front left column is missing structural material, which needs to be fixed. The parking lot side of the structure has stains that needs to be removed. 9-304B complied. 18-12A complied. Subsequent inspections were conducted, including a pre-hearing inspection on Saturday, September 25th, 2021, and the following violations remain. 9-306, as depicted in the photos. The city is requesting 35 days to comply or a fine of $25 per day per violation thereafter to be imposed.
Mr. Moncrief, are you in the room? Yes, sir. Please step up to the podium.
Good morning, sir.
Good morning.
Can you please state your name for the record?
Reginald Moncrief?
Okay, are you in agreement to bringing the property into compliance within 35 days?
Yes, ma'am.
Okay, perfect. Thank you so much.
Our next case is on page 16, Inspector Bovary Exantis, case number CE 21060382, case address 1540 Northwest 19th Avenue. Owner, Maxim House LLC, property posted 9/16/21, posted at City Hall 9/16/21.
Good morning, Your Honor. Inspector Exantis, on behalf of the City of Fort Lauderdale Community Enhancement, presenting case number CE 21060382, property address 1540 Northwest 19th Ave. Property was first inspected in June 15, 2021, and the following violations were observed. Violation 47-34.1, .8.1. There's illegal land use occurring at this property zone RS8. There is outdoor storage of, but not limited to, buckets, gas canisters, derelict grill, metal bed, tires, toys, and other miscellaneous items. This is a prohibited use as per section 47-5.11 of the ULDR. Violation 9-304B, the paved and gravel driveways are not being maintained. There are potholes in the paved driveway. The gravel approach has areas that are worn through and have grass and or weeds going through it. Violation 9-305B, the landscape at this property is not being maintained in neat and well-kept appearance. There are areas of dead and missing ground cover on the property and swell. Violation 9-305A is complied. Violation 24-27B is also complied. Violation 9-280H1, the chain link fence at this property is in disrepair and is not being maintained as required. There are holes in the fence and the support bar is missing. Violation 18-12A is complied. Violation 9-306 is complied. A notice of hearing was posted on property on September 16, 2021, and a pre-hearing inspection was conducted on September 24, 2021, revealed as depicted in the photos. The city is requesting 35 days to correct or a fine of $50 per violation for each day thereafter.
Sir, please state your name for the record.
Good morning. My name is Andras Vlaiks.
Okay, can you bring the property into compliance within 35 days?
Yes, Your Honor. We are struggling to get the grass actually delivered. So today, we were waiting for 4 weeks to get the grass done. So today, this afternoon, we are going to get it delivered, and we will actually absolutely.
Okay, sounds good. So get it done within that 35 days or the fines will start to run. You run into a problem, make sure you contact the inspector.
Thank you so much.
You're welcome.
Thank you, Your Honor.
Thank you.
Thank you.
Our next case is on page 20. Inspector Paulette Del Grasso. Case number CE 21030678. Case address 1405 North Andrews Avenue. Owner AMBT Corp. This case was first heard on 6/24/21 to comply by 7/8/21. 3 sections not complied at $25 per day. $6,225 is accrued. The city is requesting full amount and fines continue to accrue.
Good morning, Your Honor.
Morning.
Inspector Del Grasso for the City of Fort Lauderdale. The case and address are as read. This property is now in compliance. I've discussed this matter with my supervisor, and in light of the case being originally cited by Officer Turowski, who's no longer here with the city, and the owner believed the violations were in compliance by taking measures that he thought were sufficient, the city is seeking hard costs only of $718.
Okay. Please state your name for the record, who's ever going to speak.
I'm Kenneth Trent, property owner's representative, and also coincidentally a tenant at the property.
Okay.
This is Mr. Cohen, who's the owner.
All right. Are you in agreement with reduction to city costs of $718?
Well, we certainly appreciate removal of the accrued fines and all of that. However, there is an issue. We would seek a reduction of that $700 amount simply because Mr. Cohen didn't have notice of the June 24th hearing at which the final order was entered. There was a notice apparently posted, but there's another tenant at the property because it's been made into a duplex. And I recall, I've been sworn, this person taking the notice down, which I hadn't seen at that point, asking me what it was, and I said, hey, it's a code enforcement thing. We have to tell Audie, Mr. Cohen. And at that point, she never notified Mr. Cohen according to his phone and from what we've been able to figure out. So we're asking that there be a further reduction. We do appreciate the accommodation. The thing about the first violation about the stuff that was on the porch there, that was taken care of immediately, I thought, but we've had further discussions. It's not going to be any more of an issue. Mr. Cohen has gone out, gotten gravel delivered, gotten some sod delivered and installed. So we would just ask that you have mercy on us with regard to that $700 hard cost amount, if deemed appropriate.
Okay. All things considered, I think the city's reductions to cost are generous. Notice was already found in the prior hearing, so I'm going to award the city $718 in costs.
Okay.
Thank you, Your Honor.
Now, is there a payment plan, or does that just constitute a lien that has to be taken care of ultimately?
You'll get an order in the mail and notice, and et cetera.
All right. Thank you very much.
Our next case is on page 30. Senior Inspector Dorian Cologne, case number CE 21030072, case address 3821 Southwest 13th Court, numbers 1 through 4. Owner B&Y Investments LLC. This case was first heard on 6/4/21 to comply by 7/8/21. 1 section not complied at $50 per day. $4,150 accrued. The city is requesting full amount and fines continue to accrue.
Good morning. Sorry, excuse me 1 second. Good morning. Senior Officer Cologne for the City of Fort Lauderdale. Case number is CE 21030072, and the case address is 3821 Southwest 13th Court, 1 through 4. This case was originally assigned to Inspector Will Snyder, who first inspected this property on March 1st, 2021 for a broken window, exterior and disrepair, and for overgrowth, trash and debris. It came before the special magistrate on June 24th, 2021, and the magistrate found for the city for the remaining violation of the overgrowth, trash and debris and granted 14 days to comply or a fine of $50 a day thereafter. I conducted a reinspection on July 8th, 2021, as well as in August and in September. However, the violation remains as depicted in the photos, which I would like to be entered in for the record. And the city is requesting full imposition of the fines which continue to accrue.
Sir, please state your name for the record.
Matatia Cohen.
Okay, why haven't we picked up the trash and?
Yeah, I
debris?
have the gentleman that was before the lady that was the inspector. He told me before he left, that's why I didn't appear in court on the 24th, because he said everything was fine. I have somebody there that picks up the trash, is one of the tenants. He picks it up when he comes from work every day. And because we used to be on a corner, we used to have a dumpster there, and people used to dump the stuff. So we took out the dumpster, but there is people that come and drop stuff. So he takes it to the dumpster, but he does it after work every day. So, and I asked the lady before, because I met with Will, his name was Will, the gentleman before her, and I met him and I explained to him that the guy does it sometimes, like she can come and see the thing, but the guy at the end of the day, he cleans up the place. So I asked to meet with her, and I was never able to do it, for the past months, because I wanted to know exactly what it was that I'm doing wrong. We have somebody that cleans up every day when they come back from work. So I don't know what else to do.
Anything else?
I mean, it's pretty clear. It's just the trash and debris is all over the, you can see it's on the sides and in the front. It's
But
just a matter of picking it up.
They pick it up every day. They come and they pick it up every day. And I have somebody who does that.
I know, but the pictures show otherwise, and the property owner is ultimately responsible, so.
I understand.
The fines are gonna continue to accrue until this inspector can come out there and see that there's no trash there and comply the case.
When there is trash, ma'am, they put it, and then that person who's in charge, when he comes from work, he picks it up. And that's all I can do. How else? I cannot have somebody 24 hours a day there. It's like, it's not the people, there's other people that come and throw the trash there. It's not the tenant necessarily.
I realize that, and people come in front of me all the time and say, well, I didn't throw it, it's not my trash, but it's on your property, so the law says you're responsible.
I understand, but I do clean it every day. And I said, if you want, we can meet there and I'll show you when the guy does the cleaning so you can
Well,
understand.
I know you believe it's being cleaned every day, but the fact that the inspector's been out there 3 or 4 times or whatever, and it's still there, says otherwise.
And the other inspector, the reason I didn't appear on the 24th, because there was a date on the 24th, because he told me everything was fine, he understood what was going on, and he said he's going to sign off, but he never did, and he left. And then the lady came in, and we are in this position now.
Okay, when was the last time the property was inspected?
Just yesterday or the day before, it was on 2 days ago.
Okay, I'm going to impose the fine that will
What was
continue
on the-
to accrue until the property's complied.
I'm sorry?
I'm imposing the fine that will continue to accrue until the property is complied by the inspector.
What
can
was
speak-
it? You have a picture of what happened 2 days ago, ma'am? You have a picture of what was wrong 2 days ago, please?
I'm sorry.
You have a picture like what happened, like what you saw 2 days ago?
The pictures were being displayed on the screen as we're talking.
Where?
Okay. I've been looking at them this whole time, sir. Okay.
I'm sorry?
I have been looking at them this whole time.
Yeah, where is the, I'm talking the picture from 2 days ago. What do,
Well, these are from September.
this is from before.
Yeah,
Hold
these
on.
are from
This is not from
September.
2 days
Sir,
ago.
sir, please do not speak while I'm speaking.
Yeah, I'm sorry.
These are from September 16th, and she has testified that she was out there 2 days ago and it's in the same condition. So
But
I've made my ruling, sir. The fine is going to continue until the inspector complies it and there's no trash there. Okay, thank you.
Okay.
Thank you.
Our next case is on page 23. Senior Inspector Leonard Champagne. Case number CE 21050646. Case address 741 Bayshore Drive, 34N. Owner Roger Bjun. This property was first cited on 7/3/21 to comply by 7/18/21. One section complied at $200 per day, $5,200 accrued, and the city is requesting full amount, and no appeal was received by the deadline. Good morning, Mr. Flowers. Can you please raise your right hand?
Yes, ma'am.
Thank you. Do you swear and affirm to speak the truth at today's proceedings?
I do.
Thank you.
Good morning, Your Honor.
Good morning.
Leonard Champagne for the city. Case number CE 21050646, located at 741 Bayshore Drive, Unit 34N. I'm presenting this case from Darren Emmons, who originally cited the property on 7/3/21, and the property was cited for 15272A. Property is being utilized as a vacation rental without the required certificate of compliance from the city. They were allowed 15 days to come into compliance. The violation did not comply until 8/14. The appeal deadline was 7/18/2021, and no appeal was made. The city is requesting the full imposition of fines.
Okay, somebody here for the property owner?
Yes, Your Honor. It's Richard C. Flowers. I'm an attorney representing Dr. Bjun. Your Honor, we dispute the citation. This is basically a condo hotel. It's approximately 36 units. They're all separately owned by individual owners. The condo association rents out these units to transient occupants for 30 days or less. And as the representative of the unit owners under the city code section, it obtained the license on behalf of the entire building and all the unit owners. I've submitted that license. It is the proper license to operate these condo units as transient hotel units, basically. And so we're not sure why we're in violation. The license itself says it's for 3 or more apartments. So technically, all the units can be used as transient hotel units. This property's on the beach. It's very popular for transient rentals. And everyone in the condo, almost all the owners, use their units as transient hotel units under this license that I submitted. So we're disputing that we're in violation. The condo association, as a representative of all the unit owners, has obtained the proper license. So we've heard stories of this happening to other condo hotels up and down the beach, and the unit owners have successfully challenged it. I don't understand how we would issue a license to the condo association that represents and manages all of these units. In fact, the rent that's paid for these transient occupants goes to the condo association. They take out their fees, their management fees, and they remit the balance of what was paid to the unit owners. So the whole condo hotel is being operated as a proper condo hotel under the business license that I've submitted to Your Honor.
Okay.
Your Honor, may I approach and give you some information?
And Your Honor, if you do look at the city code section, it says not only does a unit owner have to obtain it, or their representative can obtain the license. Here, that is the case. The condo association is the representative and the manager of all the units in this building. So the license applies to the entire building and to all the unit owners. It's a standard condo hotel setup. I'm over here in St. Petersburg, but we do it over here on the West Coast. I'm familiar with it being done all up and down the East Coast, including Miami Beach. So this is the proper structure. The condo association's attorney has confirmed with me that they have the proper license for all the unit owners to rent out their units as transient hotels for 30 days or less.
Your Honor, if I may, I gave you the paperwork. Number one, I'm the senior code officer of vacation rentals, and I've gone through this on many, many, many occasions from places that are condos and where they have a name of a condo and who are managing it is immaterial. If every condo, if you see in that on that paper I gave you, the top, a vacation rental shall mean any unit or group of units in a condominium. What we go by on that, if you have a hotel, motel, or something, you would not be listed. If you look at on the usage on the Broward County, its usage is 04. And then if you look at the other sheet, 04 is designated as a condominium. If a condominium is owned separately and has its own separate folio number, it's a separate folio number just like any home or any other location, any other property. Okay, so that would be each one. We have condos that have 200 condominiums in a unit on the beach, so I don't know where he's getting his information from, and they all require a condominium and a license for a short-term rental. It is not a hotel. We have hotel condos like the W on the beach. One building is one, the other is a condominium. Every condominium is in there is being rented by a management company, and the management company, they're all licensed as vacation rentals.
Okay.
Or should be licensed as vacation rental.
Your Honor, if I could respond, if you look at section 15-272A, it says the unit owner or his or her authorized representative has registered the property as a vacation rental property. The condo association did that. It says 3 or more units, but the entire building is covered as the representative of the unit owners. They've complied with the city section.
Okay, Counselor, unfortunately, this was issued a citation and
Yes.
no appeal was filed.
Correct.
Well, unfortunately, I was not retained until after the appeal period had transpired.
The result of that is that the code on citations says that I shall impose the fine. It doesn't give me any discretion.
Your Honor, I have tried relentlessly trying to get in touch with the proper person to talk about this citation.
Well,
I only talked to Officer Emmons once, and he referred me to somebody else who never returned my calls. So,
Sir, can you please stop talking while I'm talking? If you were not retained till after the time for appeal passed, okay, it was too late at that point to make these arguments. These arguments, while may or may not have been valid, should have been made in an appeal. This is not an appeal. This is an imposition of fines case, and the code is clear that I shall impose the fines. Now, you could appeal that. You could go for lien reduction. You could do what you want after that, but I have to impose the fines based on the citation code.
Your Honor, can I just please, this is Portia, can I just clarify so that the attorney understands what he must do to comply?
Please.
So the city of Fort Lauderdale, sir, does not have a collective license. You may have a collective business tax license for the building, but the way that our vacation rental program is set up, you must register each unit individually. So you will need to contact us. There is no collective license for the city of Fort Lauderdale. I hope that clarifies what I believe is the confusion.
Okay, I appreciate that. I'll relay that to my client. But he's not currently renting it out. It's been vacant since he had the citation, so it's not being used as a transient rental right now. But thank you for that clarification. I appreciate it.
You're welcome. No problem. Portia Williams,
Okay.
Assistant Director for the record.
Thank you, Counselor.
Thank you, Your Honor.
Thank you, Your Honor.
Our next case is on page 22. Inspector Brian Lopez, case number CE 21060160, case address 500 East Las Olas Boulevard. Owner, Loica Property Owner LLC. This property was cited on 6/7/21. To comply by 6/7/21, one section complied at $250. The city is requesting full amount, and no appeal was received for this citation.
Good morning. Brian Lopez, Co-Compliance Officer for the City of Fort Lauderdale, presenting the affirmation case and corresponding property. This property was inspected on June 5th, 2021. The inspection revealed that the property was in violation of City of Fort Lauderdale Code Section 17-6. Citation was posted by Code Compliance Officer James Fetter on June 7, 2021. A reinspection by Officer James on June 25th, 2021 revealed that the property was in compliance. The city is requesting the full imposition of fines.
Sir, please state your name for the record.
Good morning, Scott Weisselberg on behalf of the tenant, Salt 7.
Okay.
Also here, Your Honor, is the representative for Loika, which is the actual owner of the Icon property where Salt 7 is located.
Okay, has your client filed an appeal in this matter?
So we contested the validity of the actual notice, Your Honor, in a timely fashion, requesting the hearing.
See, that's probably that's the problem, because the citation code says that you can't challenge anything unless you file for an appeal or a request for administrative order, and that includes notice.
On the actual notice itself, Your Honor, that's not as visible as Your Honor is pointing out. And so I understand when we got the actual notice, I've been in touch with Ms. Williams from the very beginning of the process. This is the second time that we've been rescheduled to have this hearing as to the validity of the actual notice of violation. At no time in any of these discussions with the city has there been a suggestion that a notice of appeal, which is not, again, when it was delivered to the actual property, there's no notice to the actual tenant, there's no notice to the owner of the requirement to do so. And so I can hope Your Honor can appreciate that without actually giving notice, along with the actual notice of violation, that anything other than a timely, within 14 days, request for an administrative hearing as to the validity of this notice, that was what was requested. That was the requisite filing by the actual tenant to challenge the validity of this violation.
Okay, are you saying that a request for administrative hearing was filed?
What I'm saying is that the actual timely notice of a request for a hearing was sent by my office, requesting and seeking
Within the 14 days?
Absolutely. There's two of them on file, and I think Ms. Williams, who's here, can attest to both of those being submitted to her office. They're in their public records, and that, I'm not showing up here just by chance because of a notice of a hearing. We sent a letter from my law firm requesting an administrative hearing pursuant to the specific language contained in the notice of violation to do exactly what we're here to do today, Your Honor. So I have both of those notices were sent along with a copy of the notice of violation to the city.
Is there any way to check if he's filed a notice of request for administrative hearing?
If you will give us one moment to recall this case, Your Honor, I'm not going to say you're being dishonest. I just recall our first discussion being a request by you for us to reschedule the case.
No problem.
So I will look. I'm not saying that you're being dishonest.
Sure.
And I will say this also is if you challenge the validity of the citation itself, we would have had that discussion. So
I have the letter. If you want, I can pull it up and email it to you while we get recalled.
Okay.
There's no doubt there's two of them that has been sent to your office. So.
Okay.
Okay, we'll recall this case. Next case.
I actually want to, just for the record, I want to correct something. It was on June 8th when James revealed that the property was in compliance. I said the wrong date before.
Okay, so there was only out of compliance for 1 day, $250.
Apparently 1 hour, yes.
Okay, so, all right. She will check, and if you filed the appeal, then we'll go from there.
I'll find the letter.
I'm calling the appeal the same as the request for administrative hearing.
Yeah, understood.
Okay, all right. Okay, next case.
Our next case is on page 21. Senior Inspector Wilson Quintero, case number CE 21050737. Case address 3431 Jackson Boulevard. Owner Dion Morris and Maurice Walker. This case was first heard on 7/29/21 to comply by 8/26/21. 3 sections not complied at $25 per day. $2,550 accrued, and the city is requesting full amount, and fines continue to accrue.
Good morning, Your Honor.
Good morning.
Senior Inspector Quintero, senior number 269 on behalf of the city. Case number CE 21050737 for the address located at 3431 Jackson Boulevard.
This case first came to a special magistrate on July 29, 2021, where evidence was presented and a special magistrate party filed for the city. The violations were cited on 5/22/2021. There were conversations by phone and in person with the property residents. During this conversation, the status of the violation and corrective action was discussed. The case is not in compliance, and is the position of the city that the fines being imposed as read.
Sir, please state your name.
Maurice Walker.
Okay, and why haven't we made more progress on all of these?
Your Honor, I am evicting the tenant. I went to one administrative hearing with the judge, and the tenant did not show up for the mediation, and then another mediation, and the hearing, final hearing is now set for the 12th of next month.
Okay.
The tenant parks on the lawn, so if I was to put down grass on the lawn, it will only be run over, and soon I'll be back here again. I need the tenant out of the property.
Okay, all right, and anything else from city?
No, Your Honor, it's up to you. I think the last representative from him, the lawyer, didn't say nothing about the eviction or anything.
I'm sorry.
The last person who was over here in the meeting, she didn't mention anything about the eviction or anything like that. So
Okay.
he just mentioned that just now to me. So I wasn't aware or anything.
Your Honor, I went to the city of Fort Lauderdale and I showed my mediation letter and I left a copy for him. And I called because they gave me his phone number. I went at 8 o'clock in the morning and he wasn't present. I went at 3 o'clock in the evening and he wasn't present. And no one has ever contacted me. My phone number is there and my address is there and the mail does not come to me.
Okay, when is your next hearing on the eviction?
The 12th.
On the 12th of October?
Yes.
Okay. I'm going to give you 28 days to bring the property into compliance. I'm going to give you an extension. And if you can't get the tenant out, you're going to have to tow these vehicles. I mean.
Yes. I'm going to clear everything, Your Honor.
Okay, all right. Well, I'll give you 28 more day extension, and after that, the fines are going to continue to run.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Our next case is on page 31. Inspector Bovrig Xantis, case number CE 21060481, case address 1395 West Sunrise Boulevard, owner the Kappa LLC. This property was cited on 6/18/21 to comply by 6/20/21. One section complied at $200 per day, $12,800 accrued. The city is requesting full amount, and no appeal was received by the deadline.
Good morning again, Your Honor. Inspector Xantis on behalf of the City of Fort Lauderdale Community Enhancement. Case number CE 21060481. Property address 1395 West Sunrise Boulevard. This case was first inspected on June 19, 2021 by Inspector Patrice Jolly, and a citation was issued allowing 48 hours to comply or appeal citation within 15 days. I conducted a reinspection on June 23rd. 4 days after the violation was issued, revealed property was not in compliance. Another reinspection was conducted on July 2nd, revealed property remains in violation. On August 4th, 2021, I reinspected the property and property was actually in compliance. A notice of hearing was posted on property on August 12, 2021. An appeal was not received within the 15 days. And the city is requesting all fine to be imposed.
Okay. Please state your name for the record.
Yes, my name is Leonor Mendoza, on behalf to the Kappa LLC and the property management of the shopping center.
Okay. Has an appeal been filed in this case?
Yes, we have a situation with the garbage and everything, but we because of the truck for the garbage, they block and
No,
broke.
but I
all-
want to know if an appeal or a request for administrative hearing was filed. That's
Yes,
all.
Yes.
Okay, they're saying no appeal was received. Do you have a copy of what you filed?
I'm sorry, I don't understand what
Do
you
you
said.
have a copy of of the appeal or the request for administrative hearing that you?
Oh, no, Mr. Honor, no.
Okay.
Your Honor, there was no, I'm sorry, Katrina Jordan on behalf of the city of Fort Lauderdale, there was no appeal filed of record.
Okay, all right. Okay, so the same thing I said before. If you do not file for your appeal within 15 days of getting the citation, then you waive all your rights to argue anything you want to argue, and it's deemed admitted, okay? So, you may be able to go for lien reduction, there are other avenues, but for now, I have to impose the fine. That's the code mandates that I shall impose the fine, so.
Yeah, but as soon as we have everything, we, call and do exactly what happened, because we have a situation with the truck when they broke, the place, and that's why we have an issue with the company. So that's why I want you reconsider, and then we do the fix and we put,
What I'm trying to tell you is I can't give you consideration because the law doesn't give me any discretion unless you file an appeal, so. I have no alternative but to impose the fine.
Okay, I'm ready.
You
Thank
can
you.
apply for a lien reduction, but, learn about that process.
Okay.
Thank you, Your Honor.
Okay,
Your
thank you,
Honor,
Anna.
for the same property, there's another case on page 36. She has another case on page 36.
Right.
Yes.
So we're in the other case also?
Yes. So on page 36, case number CE 200204119, case address 1395 West Sunrise Boulevard, owner Da Capa LLC, Inspector Patrice Jolly. This case was first heard on 4/29/21 to comply by 6/3/21. One section complied at $100 per day. $8,900 accrued, and the city is requesting full amount.
Good morning, Your Honor. Inspector Patrice Jolly for the city. Case number CE 2002-0419, property address 1395 West Sunrise Boulevard. This case property was first cited on February 12, 2020 for the following violations. 9-306, the exterior building walls have not been maintained. Structural parts, including fascia and soffits, are in disrepair. There are areas of exterior that have stains and missing peeling paint. That is complied. 47-21.11.A, the landscaping at this commercial property is not being properly maintained. There are areas of dead and missing ground cover on the front and rear swales. That is complied as of 9/1/2021. 47-19.4.D.1, the door of the dumpster enclosure is broken and has fallen off the hinges. An enclosure needs to be repaired and painted. That has been complied. 47-20.20.H, the parking facilities are not maintained at this property. The parking stripes are faded, and there are broken parking bumpers and the asphalt surface is faded. All violations have been complied as of September 1st, 2021. The city is requesting the fines be imposed as read.
Okay.
Okay.
State your name again for the record on this case.
Yes, Leonor Mendoza, behalf to Da Capa LLC. I worked with Patrick Jolly before, and we do, together with him, of the inspection, and we do all the painting, the parking. The only thing we missing, and I talked to him to have an extension, is for the grass, because we have a problem with the sprinklers and everything, and he said he doesn't want any issue with that, and he's going to give us the extension, and he explained to me like his last case, so I'm going to receive that. And the time, I have health situation and everything, we even comply and finish. If you see, everything is done, like cleaning, the parking, the the grass, everything is done already. The only thing I asked for a little extension because the sprinkler situation was the grass. But then we, if you see, and I have the picture, everything is done already, before the time. The only we extend was the grass situation.
Okay, so that was in April, and it wasn't compliant until the end of August. So I did other inspections after that point. Then I went by and checked, and it was plenty time to have the grass fixed on the swale. Because she did explain to me that they didn't have sprinklers there, but I can't give her a 70, 80-day extension for grass when everything else was already fixed.
Okay.
So
All right. Because you were diligent on the other matters, I'm going to reduce the fine to $1,500.
Okay.
Okay.
All
Thank
right.
you.
Thank you, Anna.
thank you.
Our next case is on page 6. For Inspector Michael Jordan, case number CE 21020153, case address 1917 Riverside Drive, owner Khaled Chaduri, property posted 9/17/21, posted at City Hall 9/16/21.
Portia, are we going to recall that other case?
The attorney is looking for a green card for the certified mail. So I'm just waiting. You ready?
Yeah, check your email.
Okay. All right, after this hearing, I'll recall your case. Go ahead.
Good morning, Your Honor. Officer Michael Jordan for the City of Fort Lauderdale Department of Sustainable Development, Code Compliance Division, presenting case number CE 21020153 for the property address at 1917 Riverside Drive. This is an RD 15 zone residential property. On February 4th, 2021, the property was inspected as a result of a neighbor complaint. Was issued a notice of violation for the following. Section 6-5, there were chickens, exotic birds, rabbits being kept outdoors on the premises. This violation is in compliance. 18-1, public nuisance, also for the chickens, exotic birds, aquariums holding stagnant water. This violation is also complied. Property was re-inspected multiple times from the time of notice of violation. As of the pre-hearing inspection, the property is in compliance with reference to this case. City is requesting a finding of fact that the violations existed.
Okay, sir, please state your name for the record.
Khaled Chaudhary, good morning.
Okay, you understand that your property's been complied, and we appreciate that, but the city's asking me to make a finding of fact that the violations existed at one point, so that if you do it again, if there's a repeat violation, you could be subject to fines. Do you understand that?
I understand. Thank you for your time. The tenant never asked permission to get all those birds and chicken there. But on top of it, when I noticed it and I was sick, that's why I cannot taking care right away. But from now on, I'll keep an eye on the property. It's not going to happen again.
Okay, appreciate that. Okay, finding of fact granted.
Thank you, Your Honor.
Thank you.
We're recalling the case on page 22 with Inspector Brian Lopez.
So if I may, Your Honor, start this case off. Portia Williams, Assistant Director for the Department of Sustainable Development. So my contact with Mr. Weiselberg, and please correct me if I'm saying your name wrong. My first contact was on August 23rd. Mr. Weiselberg sent me an email at 5:04 p.m. requesting that I give him a call the following day. I replied at 7:10 p.m. stating that I would contact him at 11:30 or that he could contact me at 11:30 the following day. Following our discussion on August 24th, I sent a follow-up email saying, "Good afternoon, Scott. It was a pleasure speaking with you earlier. The case is being rescheduled based on your voicemail request. A new notice of hearing will be provided to you. We'll coordinate the date to ensure Inspector Lopez can be present to testify." Mr. Weiselberg sent me a confirmation at 5:03 p.m. saying, "Thank you, it was appreciated, and to have a great night." My recollection of our discussion at that time was basically that Mr. Weiselberg was asking for Inspector Lopez to be present at the hearing, and so the original hearing was rescheduled so that we could coordinate for Inspector Lopez to be present. Fast forward to this morning, Mr. Weiselberg shared a appeal notice that his office sent via certified mail. We do not have the appeal. However, I did check the certified letter tracking information, and it states that it was delivered. If it was delivered, it would have been within the 15-day appeal process for the citation. Okay. All right.
Thank you.
So Inspector Lopez will present the case.
Okay, so you're saying there was a timely appeal?
Correct. We did not receive it, but there is a certified letter for it. So we don't contest to the fact that it was appealed in a timely fashion, Your Honor.
Okay, all right.
All right.
Okay.
Your case. You got it.
So on June 5th, 2021, I arrived to the property, zone RACCC, at 11:56 p.m. for a complaint received about loud noise at Saw 7. At that time, I took 3 readings using my city-issued sound level meter. At the time, the 3 readings were 69 dBA, 70 dBA, 68 dBAs. At that time, I was fairly new. I was just recently training, right? So at the time, I didn't believe that that was a violation because I had looked at the wrong, zoning. The next day, however, the area inspector, James Fetter, based off of my DBAs, did go ahead and post the citation based off of that reading because it was found to be in violation. And then, so that citation was issued on June 7th. And then the property is found to be complied on June 8th.
And I want to add a little bit more, if I may, Your Honor. So I reviewed the citation that was issued as well as the decibels, and I asked the supervisor, Julio Davila, to have Inspector Fetter to go out and to issue the citation to SALT 7. Table 1 in Chapter 17, which is noise control, there is Section 17-6, which outlines the decibel limits for residential, commercial, and industrial areas. Based upon what I recall seeing in Inspector Lopez's case files, he was under the impression that SALT 7 was in the Special Entertainment District, which is subject to a higher decibel level, 85 decibels to be exact. The 65, or the measurements that Inspector Lopez took exceeded the 65 decibel levels for an outdoor reading, which is why I requested that Inspector Fetter issue the civil citation. So I just wanted to enter that into the record as well.
Okay. So you understand now that this is being treated as an administrative hearing because the city is acknowledging your request for hearing. And the inspector just testified, he went out there, took decibel levels, and so you're charged with 1 day of excessive permissible sound level, and the fine is $250.
I am aware, thank you, Your Honor.
Okay.
I do have, if I may approach, I'd like to give you a copy of pages that are relevant to the questions I'm going to be asking the officer. May I approach?
Yes.
Do me a favor, man. Sorry. Your Honor, thank you very much for allowing us to be here today. As you may have surmised, we contest the validity of this particular notice of violation. We do not believe that code enforcement followed the required and very specific requirements for issuing this particular notice of violation. The ordinance, Chapter 17.6, which Ms. Williams did mention, governs how these notices are to be issued, but more importantly, it governs how code enforcement is to actually investigate and enforce this particular ordinance. And if I may, I have some questions for the inspector about the day in question so that we can better understand exactly what he did or didn't do prior to issuing this notice.
You're
I'll be
welcome
very
to
brief.
question him.
I'm sorry?
You're welcome to question.
Thank you very much. Good morning, sir. How are you?
Great, thank you.
Good. How long have you been working for Fort Lauderdale Code Enforcement?
Started in May.
Okay. And at the time you were hired, did you participate in any particular training as it specifically relates to the Chapter 17.6, which is the noise ordinance in Fort Lauderdale?
Yes, we have.
Are you familiar with it?
Yes.
As you sit here today, you're comfortable that you understood it and understand it as you're here today to testify about it?
Yes, I currently do.
On June 5th, when you went to SALT 7 to take readings of the decibel levels, which you just mentioned and as are highlighted on your notice of violation, you mentioned you had a city-issued decibel meter with you, correct?
Yes.
Okay. And you were trained on how to use that as well?
Yes.
All right. And when you went through your training, were you educated as to where you were supposed to be physically present at the time you took these readings?
Yes.
Okay, and tell me what your understanding is of where you should have been physically located when you reported to the property to take those decibel readings.
So at the time that I did my readings, I was under the impression that it was Special Entertainment District, which is 5 feet away from the property.
All right. Since you've learned now that this is not, in fact, in the Special Entertainment District, does that change your understanding of where you should have been when you took these readings? Your Honor, I'm going to I don't think it's appropriate for him to get assistance from his supervisor as to my questions and the answers he's about to give. So I would request that you instruct Mr. Lopez to answer the questions to the best of his ability without seeking any help.
And Your Honor, if I could, for the record, Rhonda Montoya Hassan with the City Attorney's Office. This is not a jury trial. This is not a trial before the circuit court, and this is not a deposition. The rules of evidence are loosely applied. Hearsay, as we know, is admitted. And again, counsel's request, again, there is a little off base in an administrative proceeding.
I'm going to allow him to, you know, if the supervisor wants to help, just state your name for the record, supervisor, and, you know, if you could enlighten us with any of the questions, I'm okay with that.
Yeah, Supervisor Davila, co-compliance supervisor for the City of Fort Lauderdale. Yeah, if there's any questions, obviously, that you would have of me or you would like to address and elaborate, I'd be more than happy to.
I appreciate that. The question I thought was pretty straightforward, and that is, when you learned that this was not in the Special Entertainment District, did that change your perspective as to where you should have taken the decibel readings from?
Correct.
No, that was more of a yes or no. Did that change your understanding of where you should have been?
Is this a criminal trial?
I'm sorry?
Yes or no? I'm saying it correct.
Okay, and what is your understanding now as to where you should have taken those readings, which are recorded on your notice of violation?
Across the street, where the complainant's property is.
Okay, and let's talk about the complainant. Do you know, as you sit here today, who the complainant is in this particular instance?
We do receive that information, yes.
Okay, tell me who the complainant is, sir.
Sure. Does the city, would you guys like for me
I
to-
spoke with one of the officers, Jim Feller, who served this notice. He handed it to me personally, and I was told that there was no complainant that was known to the city, that this was an anonymous complaint.
This one, do we have?
May I? I agree. It was anonymous.
Okay.
Portia Williams. I agree. It was anonymous. I'm in the case file right now. And I disagree that it should have changed the inspector's belief on where the measurement could be taken, and I'll explain why. The City of Fort Lauderdale can be a complainant when it comes to a violation of the city's ordinance. In fact, it is the City of Fort Lauderdale versus SALT 7. So for that reason, I believe the inspector or inspectors could take measurements from the public right-of-way. And the Chapter 17 noise control ordinance only requires that we take an indoor measurement from the complainant's property when the source of the sound is within the same parcel or shares the same wall. So for that reason, I believe that the inspector's measurement was accurate, even if he did not realize it was accurate.
And if I could just add something to that, so whom the complaint came from is irrelevant, because if we go to a property on the basis of a complaint and we observe a violation, there are many ways that we can address the violations, whether they come from a complaint or they are proactive in nature. Even regardless of where the complaint or the reason that where they originated is really irrelevant to that point. The inspector was across the street when he took the measurement, which is where he should have been when he took the measurement, which exceeded the decibels.
So, Your Honor, with all due respect, the gentleman just testified that he was actually not across the street, at the property line of the complainant. That is on the record. That is crystal clear. I reject that as a permissible way to take these readings. And if I handed you, Your Honor, a copy of the ordinance, and if you would be kind enough to take a look at, I believe, page 7 of 15 that I handed you, and you may know this very well from other matters that you've handled, the sound level measurements shall, which Your Honor has made clear, that is a non-discretionary term.
I know what shall means, sir.
I'm just putting this into the record, sorry. The sound level limit for the complainant's use shall apply, and more importantly, outdoor sound level measurements shall be taken on or within the real property line of the complainant. The inspector already testified clearly that he did not take these readings from the appropriate place. I don't reject that the city of Fort Lauderdale may in fact get involved on its own initiative if and when it is appropriate. I handed you a second document, which is Florida State Senate Bill 60. This started in January of 2021. This Senate bill specifically was designed, and it went into effect in June, but became effective July 1st, 25 days.
So it was not in effect at
Agreed,
the time of the citation.
agreed. But it doesn't change the analysis as to where the measurements were taken or the inappropriate location they're taken. And the reason that's important is why what you see here in the Senate bill, complainants that are anonymous are no longer investigated. They're no longer permitted to be even investigated by the city or the counties to see if in fact there is a violation. It's a terrible waste of resources. We don't know, as we sit here today, where this complaint came from. We don't know that because counsel and Ms. Portia Williams already acknowledged this was an anonymous complaint. It could have come from the water garden. It could have come from the alluvion, which is another 1,000 feet away. There are lots of very special interest conversations taking place by residents in the city, as you know, as it relates to the noise ordinance. This is one of those scenarios where there's hundreds of anonymous calls every single weekend night. I shared this bill with you because I wanted you to understand why it's changed, and I wanted you to understand the perspective as it relates to SALT 7. Without the ability to actually—
Your Honor, if I could, Your Honor, and again, for the record, Ronald Montoya Hassan, this bill was not in effect, as Your Honor has said. I doubt that council is a state legislator or drafted the bill to discuss the legislative intent of the bill, which is legally irrelevant to this proceeding. At the time, we were allowed by law to process anonymous complaints. And as Ms. Williams has indicated, the city is allowed, of course, to be a complainant for any code violation. That still is the law today. And really the only issue here was the noise in excess of the permissible sound limits. We're going a little far afield from the fairly simple and straightforward citation.
I agree with that.
Wow.
Don't talk while I'm talking. I agree with that, but I'd like the city attorney to address the portion of the code that he cited that said you had to be on the property line when you take the measurements.
So, Your Honor, I apologize. I'm not sure if I heard the beginning of this case. I was having sound issues. I didn't hear anything. I didn't even hear the case called, but I believe that Ms. Williams, so I apologize if I'm misstating something or it's already been addressed, but I believe that Ms. Williams stated, and the inspector stated, but I did not hear the beginning of the case, Your Honor, that he was in the correct location because the city is the complainant in this case. And Ms. Williams can correct me if I'm stating that incorrectly.
No, I agree. Rhonda, the statement that I made is that the city of Fort Lauderdale can be a complainant, and for that reason, sound measurements can be taken from the right-of-way.
May I, Madam Magistrate, that may be accurate, but I don't think anyone in this room can contest, nor Ms. Williams, that that was not what happened here. There was a call to code enforcement. There was, in fact, a inspector that went out to take the sound readings pursuant to a complainant. Sure. That complainant is what initiated this call, not the city of Fort Lauderdale on its own initiative, understanding whether it's through driving through the neighborhood and understand there's a problem. The specific reason that this ordinance requires that the readings be taken from the complainant's location and property line is for that specific purpose and to address the complainant's problem. That was not done here. The inspector admitted that that was not done here, and the ordinance does not give any wiggle room as to where the readings should take place. And I respect counsel who chimed in to suggest that the city of Fort Lauderdale has the right to pursue claims of its own. That's true. I don't doubt that. But this code violation, this notice that was issued on the day in question, was initiated by an anonymous phone call to the city of Fort Lauderdale. That is not in dispute. Now they're trying to suggest, I'm not saying Ms. Williams is suggesting, she's just clarifying that if in a scenario that does exist, the city could in fact be the complainant, but in this case, they responded to a call that was anonymous 25 days before the statute changed, which prevents that from even happening. And even then, the inspector acknowledges he took the readings from the wrong place at the wrong location in violation of the ordinance.
Okay, well, again, I'm not going to consider legislation that wasn't in effect at the time, but I do have some concerns that this was an anonymous complaint, and if the code says that you have to be on the property line in an anonymous complaint, I don't think subsequent to that complaint you can take the position that the city initiated it. Is it the testimony here today from the city that it was initiated by an anonymous complaint?
I'm going to say this, Your Honor. I cannot confidently say it, and I'm going to explain why. At one point, SALT 7 had a series of complaints from neighbors from the Grand. At one point, we had inspections that were directly related to those complainants, and we took measurements from the balconies of those complainants, which would have been their property line. At a certain point, the division itself began regularly scheduling inspections every weekend so that we could basically be responsive to the community. So while this exact inspection may have been a result of an anonymous complaint, I cannot say it confidently because I know that there was also a time frame within this same period where we were also proactively doing the measurements because the community was consistently complaining. So.
Well, I'm only here.
Additionally, Your Honor, if I could just add, if there's an anonymous complaint, it's basically impossible for the city to ascertain where we're taking the measurement from, which is why the city goes out, as Ms. Williams said, and takes readings where the city is the complainant. And as counsel said, there has been issues from a number of different neighbors. With an anonymous complaint, we don't know which building that would be. So we wouldn't know solely based upon that complaint where to exactly take the measurement. Hence why the city goes out and takes measurements as the complainant.
Okay, so is it the city's testimony that every time they get an anonymous complaint, they go out as the city?
Yes, prior to July 1st, yes, that is the truth, Your Honor.
Special Magistrate, I just may add that, and that is common practice usually for a property, any property, whether it's noise or otherwise, when the city receives numerous complaints accumulated, whether some were anonymous or not. Typically, the city will proactively inspect, and it's really quite a common practice on various complaints that happen in the evening, especially where we will proactively go out and inspect those properties in the evening. So if we go out to a property, whether it was complaint originated from a complaint or not, any violations that we see at that property, regardless of how it was originated, we are going to issue violations, or we have the right to issue violations, obviously before the Senate bill was passed. And such is the case here. We received a complaint. We had received numerous complaints previously, as Ms. Williams stated, from neighboring properties. So this was on our radar to proactively inspect and monitor, which we did also because there was a complaint that was received. So we were at the property. The reason for being at the property It's kind of irrelevant. We took the measurement from the correct place, and the fact of the matter is the property was in violation of our required decibel readings.
Your Honor,
Okay.
one thing before you consider what he just said, it's been addressed and testified to that where the actual readings were taken. The ordinance is very, very clear, and I think Your Honor understands what the property line means. In their system, it does in fact, it's required to code who is the complainant. If it's anonymous, their system is supposed to record who in fact for each open complaint that they investigate, whether it's a drive-by, that's a different question. But this notice, Mr. Feller, who I met with, told me clearly, and I'm here under oath as well, told me very clearly this was served on, or the inspector came out to Salt 7 on the night in question of June 5th, pursuant to an anonymous complaint by a resident. Now, I understand they're trying to shift this so that you can associate this notice
The
with
problem
something.
I'm having, Counselor, is how could you ever take readings from a property line from an anonymous complainant if you do not know where their property line is?
That's why the Senate changed the actual law.
Okay,
And I
but
agree with
that-
you, but the city can't modify its behavior to try. I understand that they have good intentions to be out and police the sound in the city. The ordinance that they have to comply with is the same one that you're asking that my client and I comply with. And if they don't comply with that ordinance, the terms shall are there for a reason. And I know you know that, but just like when you told that gentleman you have no choice but to assert a $765 fine, this same law applies here. The law was changed to fix this problem that these gentlemen and women have been having. You can't do it any longer, but that doesn't mean that you can modify the ordinance to suit your purposes. They have to be strictly complied with, just like we as residents have to strictly comply with it. And you, as the magistrate, I believe it's fair for Your Honor to say these parties have an obligation to strictly comply with the terms of the ordinance as written. If you're an anonymous complainer, then I can understand they would say, we can't respond unless you give us the location of your residence, and we're happy to come out and serve the ordinance. If they choose not to ask the resident or the person complaining for their location, that's a choice that the city makes and accepts. I understand that. That's now been fixed. But on June 5th, this was the law.
Okay, anything else from the city before I rule?
No, Your Honor.
Okay.
No, Your Honor.
City Attorney, anything else?
No, Your Honor. I think this issue has been well debated.
Okay.
Thank you.
All right. It appears to me that the city did get an anonymous complaint, and as a result of that, went out to the property. And while I can understand where the city kind of changes hats in that period of time because there's no way to determine under the statute where the anonymous complainant's property line is, this was also a history with the property that they were making regular visits to. However, there's enough evidence to show that this visit on this night was an anonymous complaint, so I'm going to fine for the property owner.
Thank you, Your Honor.
Thank you, Your Honor.
Our next case is on page 37. Inspector Patrice Jolly. Case number CE 21070090. Case address 432 Northeast 12th Avenue. Owner Craig Lowy. This property was cited on 7/8/21 to comply by 7/23/21. One section complied at $200 per day. $9,200 accrued. The city is requesting $3,960, and no appeal was received for this by the deadline.
But she said it was on 4th Avenue.
Good morning, Your Honor. Inspector Patrice Jolly presenting case CE 21070090 for the property located at 432 Northeast 12th Avenue. This property was cited on July 23rd, 2021 for violation 15-272.8, operating a vacation rental without the required certificate of compliance from the city. 15 days were given to comply. This property was out of compliance for a total of 46 days at $200 per day. No appeal was filed in a timely manner. The city is requesting the full imposition of fines.
Okay, I have here that the city's requesting $3,900.
Excuse me. Well, the fines as read, I apologize.
Okay, so what's the city's position?
Is to impose the fines as read.
The $9,200?
No,
The reduced one.
the 3,960.
Okay, sir, please state your name for the record.
Milik Novovich.
Okay, are you in agreement with the reduction of fines?
Yes, that's fine.
Okay, thank you very much.
Thank you, Your Honor.
Our next case is on page 34. Inspector Gail Williams. Case number CE 21070018, case address 5701 Northeast 22nd Way, owner David Knezvich. This property was cited on 7/7/21 to comply by 7/22/21. One section complied at $200 per day. $11,200 accrued. The city is requesting full amount and fines continue to accrue. And no appeal was received by the deadline.
Good morning, Your Honor. Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 2107018, address 5701 Northeast 22nd Way. This property is being utilized as a vacation rental with an expired certificate of compliance from the city. On July 7, 2021, the property was found advertised for rent with an expired certificate. The following violation, 15-281.A, was cited and a citation issued. The property was given 15 days to comply and 15 days to appeal the citation. No appeal was filed. The city is requesting the full amount to be imposed.
Sir, please state your name.
Zachary Manuel, counsel for the property owner.
Okay, did your client timely file an appeal?
Your Honor, my client was out of the country for 6 months.
Okay. It is really, that might have been a good excuse, and I might have been able to have some discretion if the appeal was filed, but it wasn't, and I have no alternative but to impose the fine.
Thank you, Your Honor.
Thank you.
Right, thank you.
Our next case is on page 16. I'm sorry, we've already had that case. Our next case is on page 22. Inspector Anthony Flores. Senior Inspector Dorian Cologne presenting. Case number CE 2108016, case address 2801 East Oakland Park Boulevard, owner Oak and Bay LLC. This property was first cited on 8/10/21 to comply by 8/11/21. One section not complied at $250 per day. $12,250 accrued. The city is requesting full amount, and fines continue to accrue, and no appeal was received by the deadline.
Good morning again. Senior Inspector Cologne for the City of Fort Lauderdale. Case number is CE 21080316. Case address is 2801 East Oakland Park Boulevard. Myself, along with my trainee at the time, Inspector Flores, responded to a complaint in reference to trash and debris at this property and as well as others in this particular alleyway. We observed boxes and trash throughout this property, as well as plastic bins being stored next to the dumpster area. We spoke with the management at each establishment about the violations and what was expected of them for compliance. And a citation was issued and posted at the property, allowing 24 hours to remove all items and debris. There were at least 5 inspections made. However, the nuisance still remains as depicted in the photos that I would like to enter into the record, as well as the affidavit of mailing and of non-compliance.
Okay, it'll be received.
And, sorry, and the city is asking for a full imposition of the citation. And fines continue to occur.
Okay. Please state your name for the record.
Steve Shin, S-H-I-N.
Okay. Did your client file an appeal to the citation?
No.
No, okay. Same as before. I have no discretion except to impose the fine. You know, you can go through lien reduction or whatever processes are out there, but for today, the law requires me to impose this fine.
Okay.
Okay, thank you.
Thank you.
And it continues to accrue, so I would really suggest that you put a stop to what's going on out there.
Yeah, I'm having a little bit of trouble with our main tenant, CVS, and they're our main tenant, and I've defaulted them, sent them notice to
Unfortunately, it's still
Rhode
the
Island. And,
property owner that's on the hook for it. So.
right, I can't, in that instance, with their store fixtures in the back, I don't have the ability to self-help. I can't build a structure to how, I've told them, look, you've got to comply. I'm defaulting you, I'm giving you a 30-day notice to comply, but I can't, as owner, drag your equipment, So I've defaulted them, sent them certified notice, and they've acknowledged that we have a problem. They just won't work with me to help remedy the situation. So I'm kind of at either I terminate their lease or, send them.
Okay. Unfortunately, everybody has tenant problems, but it's still the property owner's responsibility. It's the way the law is written. Sorry.
Understand.
Okay, thank you.
Thank you.
Thank you.
Our next case is on page 30, Inspector Boverick Xantis. Case number CE 200-20244, case address 1312 Northwest 15 Terrace. Owner Guardi Joseph Alexis. This case was first heard on 6/4/21 to comply by 8/26/21. 2 sections not complied at $50 per day. $3,400 has accrued. The city is requesting full amount and fines continue to accrue.
Good morning again, Your Honor. Inspector Xantis on behalf of the City of Fort Lauderdale Community Enhancement, case number CE 2002-0244, property address 1312 Northwest 15 Terrace. This case was first heard on June 24, 2021. The magistrate ruled in favor of the city, and the property owner was ordered 63 days to correct all violation. A notice of hearing was posted on property on September 17, 2021, and a pre-hearing inspection was conducted on September 25th, 2021, revealed all violation remain in the city as depicted in the photos. The city is requesting the full imposition of fines and fines to continue to accrue until property is brought to compliance.
Okay, please state your name for the record. Who's
Alex.
going to speak today?
Alexis Gerdi Joseph.
Okay, can you move closer to the microphone, please? Okay. And why has this property not been brought into compliance?
That's not my fault because that's how I was born. Insurance sign money for contractor, that's contractor steal money, they don't do nothing. Me have big problem because I don't have no place for sleep. I go to court to him. That's all my paper from court. Because contractor take all my money, they never do nothing. Where I call him, they never answer your phone. So that's problem. I go to court to him.
Your Honor, I assisted the homeowner as contractor on the property, and we did pull permits, and we did replace and install the windows, as you can see in the picture that the windows are now installed. However, we have not been able to afford the roof yet, which we are hoping to complete that within the next 30 days, because the insurance company released some funds to me so that that could be done. And of course, she's correct. The insurance company paid out $90,000 to the contractor that did nothing, and that left her in a bind. I fronted my own money to start the project. The insurance company is refunding me some of my money, and I'm using my money to finish the roof and paint the building. Okay. And that should bring the property in compliance. I'm just asking for a little bit more time. The check from the insurance company has not yet got to us. We should receive it before the end of the week.
Okay, how much time do you think you need to complete the property and bring it into compliance?
If you could give us 60 days, I'd appreciate it.
What's?
City will not impose to that, Your
Okay.
Honor.
All right, we'll give you 63 days to complete the project and bring the property into compliance, and I'll suspend the fines during that time.
Thank you very much.
Thank you so much.
Thank you, Your Honor. I just want to state one last thing, Your Honor. The windows are not all in compliance, so the violation remains. So.
Okay, maybe you could have a word with them.
Thank you, Your Honor.
Wait and speak to the inspector so that you know what the problem is in order to comply the case, okay?
Thank you, Your Honor.
Thank you.
Our next case is on page 24. Inspector Michael Jordan, case number CE 2005-0618, case address 2124 Northeast 63rd Street, owners Linda Aceta and Jonathan Gonzalez. This case was first heard on 2/25/21 to comply by 4/1/2021. There are 2 suspensions notated on the agenda. 7 sections complied at $100 per day. $41,900 accrued. The city is requesting full amount, and this was in order to reappear.
Is counsel for the property owner present?
Good morning, Mr. Siegel.
Hello?
Good morning, Mr. Siegel.
Hold on a second. Hold on, I'm here, I'm just trying to, there we go. Am I on here now?
Hi, can you raise your right hand, please? Do you swear and affirm to speak the truth at today's proceedings?
I do.
Thank you.
Good morning, Your Honor. Officer Jordan for the City of Fort Lauderdale. Property address and case number as read. On May 20th, 2020, this property was issued a notice violation for violations of Section 9-276, extermination of rodents, 9-305B, landscape maintenance, 9-308, roof not maintained, 9-306, exterior maintenance, 9-280B, building parts not being maintained, 9-280G, electrical wiring and fixtures inoperable. All these matters have been complied, Your Honor. The property's been re-inspected multiple times. As of 8/25, all violations were in compliance. The city's asking for the full amount.
Okay.
Thank you.
Counsel.
May I respond?
Yes, absolutely. Go ahead, counsel.
I am looking at the special magistrate orders entered previously in this matter. And the order that I'm looking at on the 29th of June, 2021, vacated the prior order, which would impose fines on this property. Following that same order, on the 24th day of June 2021, there was an order which provided a date for compliance, which was originally scheduled for April the 1st, 2021, and thereafter was extended to July the 29th, 2021, and there was an order to reappear for special magistrate hearing on August the 26th, which I attended on behalf of Ms. Aceta. That order suggests that failure to bring the property into compliance may result in the imposition of fines pursuant to 162.09 Florida statutes. My understanding and and what has been told to me both by city staff and my understanding from the orders here is that should Ms. Aceta have brought the matters into compliance, that there were no fines that were accruing during that period. So in that regard, since there were no fines ordered previous to this, and there was a time for compliance, and Ms. Aceta has in fact complied, we would object to the imposition of fines at this time.
Okay, I think what he's saying is that this was first heard in February 25th to comply by 4/1, and at some point thereafter, that order was vacated. Is that correct?
That is a correct statement.
Your Honor, if I could,
Sure.
for the record, Rhonda Montoya Hassan with the City Attorney's Office. I spoke to counsel at length yesterday, and we were unable to reach an understanding. The issue, Your Honor, is, as you know, very common. When the order to vacate the imposition of the fines doesn't vacate the fines, it just vacates the imposition of the fines. And so the case was continued today, and in order to reappear, and as Your Honor sees, it's on the Massey docket to impose the fines. There was
I'm going to object at this time, Your Honor, and I'm going to object at this time to discuss that. I don't think counsel's discussion or explanation to the special magistrate as to what the actual word vacate means is appropriate. I think the word vacate is defined quite well by Florida statute, as well as by the dictionary. Vacate
counsel,
means,
you've had your talk, you've had your opportunity to talk. Now I'm speaking.
But as I was sitting here, I understood that you interjected and objected on a number of motions and a number of other attorneys' presentations, and I'm doing the same. And at this time, I'm objecting to your explaining the meaning of the word vacate.
Okay, your objection's noted, and I'll move on that later. Go ahead, Mrs. Hassan.
So, Your Honor, there was confusion at the last hearing, and so that hence the order to reappear, and as Your Honor sees, it's on the Massey docket for imposition. The case was first heard. There was a Massey hearing on May 27th. When staff and I looked at the case after the August hearing, what occurred, and Ms. Jordan can also confirm this, is that the fines were imposed at the May 27th hearing. At the end of that hearing, the property owner stated she had been in the room and she didn't hear the case called. Ms. Jordan verified and staff verified that she was in the room, but in an effort to work with the property owner, we took the case back to hearing on June 24th to vacate the order imposing the fines and allow the property owner to be heard. At that point, the magistrate gave 35 additional days to comply, stayed the fines, and ordered the mandatory reappearance on the 26th. As Your Honor sees from the agenda, there were gaps in the compliance and in the various actions taken by the magistrate. So the fines, as you see on different cases, on two of the components ran for 34 days. They had an earlier compliance because there was a gap from April 1st to June 24th. Those came into compliance during that time frame, and those were the 34 days. And as Your Honor sees, there's various days of compliance. The city is requesting the full amount, and I believe that the inspector can testify as to why we are requesting the full amount, because as Your Honor knows, normally or often when a case comes into compliance by the Massey hearing, often the city will request a reduction in the fines imposed, but in this circumstance, we are asking for the full imposition, as the inspector can fully more detail that for you.
Okay. Let me hear from you.
I'd like to just respond, if I may, briefly. I'm going to object to the characterization as there was some confusion. I was present at the hearing. I spoke with the magistrate who was seated at that time. He didn't seem to be confused. I wasn't confused. Mr. Jordan and I had a conversation. I'm pretty sure he wasn't confused.
You were confused.
Who was confused?
You were.
No, I was definitely not confused. I was
Oh, yes,
certainly,
you are. You're still confused.
All right, I want to hear from the inspector.
I apologize. Is there somebody who just told me that I'm confused? Because I'd like to know who just said that.
Sir,
I did.
Sir, I'm conducting this hearing, and I've already stated I want to hear from the inspector now as to why the city wants full imposition of the fines.
If it pleases Your Honor, before I testify to that account, the complainant in the case, the original complainant is here, would like to make an impact statement.
Okay. All right. Please state your
I'm sorry. I'm going to object to this too. This is not noticed for today. We're not here on an imposition of fine hearing.
Yes, we are.
We're here on a recall to find out there was compliance, which there was. So if they would like to have a fine imposition hearing, let's notice that so that everybody can fairly be heard.
Mr. Siegel, you need to stop interrupting my proceedings, okay? I'm going to conduct them in the order that I see fit. Please state your name for the record. Okay.
I'm the complainant in the case.
Okay, and what is it you want to tell me before I rule on fines?
Absolutely. I was a renter of this premise starting in January of last year. She purposely let this property fall into repair. She was asked many times to repair many aspects of the house, the leaking roof, the structure falling down. She would not respond or say she'd get to it later, then would stop taking my calls. So she was given ample time before I called the city to actually address any of the issues, and she simply did not. The house was in foreclosure, she had not been paying the mortgage, and she was just pocketing my rent. So she's very astute at playing the system. This is not her first rodeo on this.
Objection. I'm sorry. This is a direct attack on my client, and it's inappropriate.
In my dealings with her, it's very appropriate.
Okay. Are you done?
I appreciate, and Mr. Siegel was aware of me coming to speak.
Okay, Inspector.
Your Honor, in my professional career and in my professional opinion, the impact on the neighbors in this particular case, along with the impact on the complainant at the time, the city believes that the fines are warranted in this case, and we are asking for the full imposition of fines.
Okay. Mr. Siegel, the order to vacate, that issue aside, do you have anything else you want to tell me in mitigation of these fines?
Well, yes, I do. And as I stated previously, my client was made aware that if she complied within the period of time that was listed in the order on the 24th day of June 2021, that there would not be an imposition of fines. And therefore, in consideration of that order, my client made diligent effort to try to repair all of the problems on the property. Had I had the opportunity to cross-examine the witness standing in front of you, it would have been my pleasure at that time to describe my client's position that the gentleman standing in front of you, as a means of self-help, caused the damage and the violations, and did so he didn't have to pay rent, which he didn't do until he was evicted. So while we're having personal attacks on people, I would ask that you disregard this witness's testimony entirely. That being said, my client, after she was able to remove the tenant, was able to perform the work, and did so in a workmanlike fashion in the best way she possibly could. And again, most of the work was prevented from being performed by the gentleman standing in front of you. So I'm not sure why he decided to show up today, but again, he can stand there and take his share of the blame for what happened here today. My client is a hairdresser and not a construction worker, and did her best to get it completed as fast and as efficiently as possible. I think that when one receives an order that says if you do this in time, you won't have a fine, and then does the thing that was requested, that no fine should be imposed.
Okay,
if fines are imposed, it would be my intention to bring that up, in another forum, especially since I have the orders in writing to present to that higher authority.
Siegel, can you please let me speak? Can you point to the order that says if you comply with this, within this time frame, you will have no fines?
I'm sorry, are you speaking to me? I can't, I apologize. There's a little bit of a, I'm having a little trouble with the
You
audio.
just testified that the order that was issued on 6/24, I assume you're talking about, said if she complied within that period of time, that there would be no fines. And my
Yes, oh, I'd be happy to do that.
where in the order does it say that?
The sentence I'm reading is just above done and ordered, and it says, failure to bring the property into compliance by the dates ordered by the special magistrate may result in the imposition of fines pursuant to section 162.09 of Florida statute. Plainly read, that sentence says that if you bring the property into compliance by the date ordered by the special magistrate, that fines will not be imposed. In addition, it says that even if you do not bring the property into compliance by the dates ordered by the special magistrate, it may result, may being in the discretion of the magistrate. So I would suggest that if you bring it into compliance, there won't be fines. If you don't, then you may get imposed fines. So the plain language, I think, speaks for itself.
Okay. I'm going to let the city attorney have the last word, and then we'll.
Thank you, Your Honor. The compliance date is this very simple case. The original compliance date was April 1st, 2021. As Your Honor sees on the agenda, there were various suspensions. There were gaps in the suspension of the fines, but the original compliance date was April 1st, 2021.
That's not a, that's only a half true statement, but I'll, if I may reply, if I may not, I'll stop.
Okay. But that order, city attorney, was vacated. And it's
The order imposing the fines, Your Honor, was vacated. That didn't mean that the compliance order was vacated. It was the order imposing the fines that was vacated. We didn't vacate the original order.
okay.
And the property owner was given additional time to comply. The fines were suspended from June 24th through July 29th. And then they were suspended again from August 26th, which doesn't actually even apply because they were in compliance with everything finally by the 25th. But there is nothing in the record, Your Honor, that vacates the original order finding that the violation existed and ordering compliance by April 1st, 2021. The order vacating was the imposition of the fines.
Okay. Mr. Siegel, I'm going to ask you one question and then I'm going to rule. Did your client, is it your testimony that your client thought that motion to vacate meant there were no fines accruing?
My client, in response to getting this order, complied with the order in consideration of the idea that there would be no fines imposed.
Okay, that doesn't answer my question. All right.
Well, the answer is yes.
Okay. But I still think you're talking about the June 24th order and not the rest of them, so.
The June 24th order, and there's a June 29th order. So it was done and ordered on the June 24th, that's correct. And then there was a following June 24th order, which set a date for compliance. The order on the first order, which is the order on the motion to vacate, granted the vacation and said that the order from February 2021, which gave time through the one from April, which was originally done in February, I'm sorry, and then it was scheduled in April, was extended to the 29th, and then the 29th of June was rescheduled into July, And that hearing nobody could make, so we rescheduled the hearing for August the 26th. So there is no period or gap, as council is attempting to indicate,
Okay, so
where
this case comes down to whether or not that order to vacate vacated the fine that was imposed or vacated the accumulation of fines, okay? And what I'm being told by the city is that the order to vacate was on the prior imposition of the fines, all right? And that's generally what the order says. I don't have the order in front of me, though.
let's look at that, because that would probably answer that question.
Do you have the order for us?
I don't know if it's in, this is not that case file, but I don't know if we have a similar order in this file.
Okay, what I'm going to do so we don't hold up the rest of the hearings is I'm going to take this case under advisement and review that order, and then I'll issue a ruling.
I appreciate that, but just as a final note, I'm going to say that the order doesn't vacate just the part of the order. It says it vacates that order. So I think that the argument as to whether or not it vacates one part and not another part.
The previous order was to impose the fine.
And the findings, I imagine there was a finding on it as well. I think the argument's specious, and I think that the document should speak for itself.
Stop talking while I'm talking. I'm going to review all the orders in this case and take it under advisement, and I will issue a ruling after I do that.
Thank you very much.
Thank you.
Thank you, Your Honor.
Thank you.
May I be excused?
Yes.
Thank you.
Our next case is on page 36. Inspector Patrice Jolly. Case number CE 21070868. Case address 1332 Northeast First Avenue. Owner Andrew Evangelisti. This property was cited on 7/24/21 to comply by 8/7/21. One section complied at $200 per day. $1,000 accrued. The city is requesting full amount, and no appeal was received for this citation.
Good morning, Your Honor.
Good morning.
Inspector Patrice Jolly for the city, presenting case CE 21070868 for the property located at 1332 Northeast First Avenue. This property was first cited on July 24th, 2021 for the following violation: 15-272.A, operating a vacation rental without the required certificate of compliance from the city. 15 days were given to comply. This property was out of compliance for a total of 5 days at $200 per day. No appeal was filed. The city is requesting the full imposition of fines.
Sir, please state your name. Okay, Mr. Evangelisti, did you file an appeal in this case?
No, ma'am, I did not.
Okay. Unfortunately, I'm sure you've heard me say this before. The code does not allow me discretion if you don't file the appeal, so I'm going to have to impose the fines.
Thank you, Your Honor.
Thank you.
Thank you.
Our next case is on page 17. Inspector Michael Jordan. Case number CE 21060298. Case address 1510 Southwest First Street. The owner is Flavio Galvin, who is in the hearing room. We're waiting on him to come into the main room in the Zoom meeting. Good morning, Mr. Galvin. Can you raise your right hand, please?
Good morning.
Good morning. Do you swear and affirm to speak the truth at today's proceedings?
Yes,
Thank you.
you're welcome.
Mr. Galvin, do you require a translator for Spanish, sir?
Yes, please.
Give us one moment. Magistrate, there's an additional case on page 25 for the same property, which is a citation. Case, I'm sorry, I'll read it once. Sorry, go ahead, guys. Gus, do you swear to translate from Spanish to English and English to Spanish?
I do.
Thank you. There's an additional case on page 25, case number CE 21060298, which is a citation, which was cited on June 10th, 2021 to comply by June 24, 2021. One section complied at $500 per day and no appeal was received for this citation.
Okay. If it pleases your honor, we'll take the citation part of the case first so that we can release the inspector who's here.
Okay.
Officer Michael Jordan for the City of Fort Lauderdale Department of Sustainable Development Code Compliance Division. Case number CE 21060298. Property address is 1510 Southwest 1st Street. RML 25 zoned residential property. On June 10th, 2021, this property was inspected by myself and Landscape Inspector Vadi, who is also an ISA certified arborist. As a result of a neighbor complaint, was issued a citation for the following: 47-21.15.a. Tree removal. 2 large trees removed from the rear yard without a certified arborist report or permit. The city's requesting the imposition of that fine. The citation was not appealed.
Okay,
Your Honor, let me translate.
please.
Buenos días, señor. Este caso es el C21060298 para la propiedad 1510 del Southwest de la primera calle. Esta es una casa residencial 25. En junio 10 del 2021 esta propiedad fue inspeccionada por el inspector Jordan y también por el señor Vadís, resultando de que fue una queja de un vecino y fue citada por la violación siguiente. 2721.15a, se removió un árbol, 2 árboles grandes de la propiedad trasera sin un certificado de un arborista. La propiedad fue también dada una notificación de violación por el 9.313a. Los números no están visibles en la propiedad. 9280H1, que también tiene la cerca, no está bien reparada. 47.341A1, que hay una acumulación de cosas personales afuera que ya fueron completadas. These are complete, right? Ya fueron completadas, y también la 92.80H1 fue completada. La violación 9.305B, la violación existe. La propiedad fue reinspeccionada múltiples veces y dada la violación y las fotografías acá de las inspecciones que todavía existen, la ciudad requiere 35 días para completar o una violación o una penalidad de $50 por cada día que persiste, señor.
Your Honor, the citation amount is $500. That's $250 per tree that was removed as for process and procedure. Inspector Viday would like to testify as to what he saw on the property.
Okay.
Señor, la violación es de $250 por árbol. En el caso total serían de $500 y el inspector Viday va a testificar.
How you doing, Your Honor? I helped Officer Jordan to identify 2 trees that were removed in the backyard. The trees were already gone. Just one stump was remaining, and the other side, the other portion of the stump was grinded down already. So the trees weren't able to be identified. And then they have to apply for after-the-fact tree removal permit to come into compliance.
El señor Badí fue a ver el resultado de la violación. Dice que habían 2 árboles que no se fueron identificados o qué tipo de árboles eran. Uno de ellos, lo que es la raíz, fue quitada y la otra es existente.
Okay, Your Honor, for English, for the record, the other violations on the property were 9-313A, house number is not visible. Very well, thank you.
You're from the property owner.
Very well.
Señor, vamos a escuchar cualquier declaración que usted tenga en este momento.
And can you also ask the property owner, Gus, whether or not he filed any kind of appeal?
La jueza está preguntando si usted dio algún tipo de notificación dentro de los 10 o 15 días que fue notificado por la violación, señor.
Sí, yo traté de hablar con Michael Jordan y fui muchas veces a la ciudad a hablar para ver de poder solucionar. Y pagué $105 por el permiso, no sabía que tenía que sacar el permiso. El árbol era muy grande y el vecino me dijo que lo quitara porque le rompió el techo de él. Y bueno, yo lo saqué sin permiso.
Okay. He basically says that yes, he actually went a couple of times to the city, tried to speak to Mr. Michael Jordan, and while he was at the city, he actually paid $105 for the permit. And the reason he removed the trees it was because the next door neighbor was actually complaining about the tree hitting his roof. ¿Algo más que quiera agregar, señor?
Bueno, estaba muy deteriorado con el dueño anterior y yo estoy tratando de limpiar todo. Entonces, había un árbol que lo llevó el huracán, entonces no sé si serán 2 árboles, por eso también, no sé.
He basically says that the area was deteriorated and he wanted to clean it at the end of the day. He doesn't remember if the tree was actually bent or the way that it was because of the hurricane, but at the end of the day, he was trying to clean his property.
Okay, but there's no appeal been filed. Okay, all right. I'm going to have to rule for the city based on the fact that we did not receive a timely appeal. Inspector, you can explain to him about lien reduction if he chooses to go that route.
La jueza en este caso, señor, va a darle la multa de los $500 porque no hubo una apelación durante los 10 o 15 días que es adecuado. Si usted necesita ayuda, aquí el señor Jordan, igual, mi nombre es Gustavo Caracas, yo le puedo ayudar a hacer la traducción si amerita ayuda también. Pero en este caso, la jueza dictamina los $500 de multa.
Okay.
Your Honor, for the record, in English, the other violations that were on the property were 9-313A, house numbers not visible from the street. That violation's complied. 9-280H1, fences in disrepair. That was complied at the pre-hearing inspection. 4734-1A1, outdoor storage was also complied. There's 1 violation remaining, and that's landscape maintenance. For the property owner, he has planted grass in the front yard, Your Honor, and it's beginning to sprout, but it's not currently in violation. Therefore, the city's asking for 35-day extension of time and $50 per day thereafter.
Okay, Gus, could you let him know what the city has recommended and if he's in agreement with that?
Caballero, con referente a las otras violaciones que existen en su propiedad, el oficial Jordan dice lo siguiente, que la violación 9313A con referente a la numeración de la casa ha sido completada, 9280H1 ha sido completada, 47.34.A1 ha sido completada y la única violación que existe en este momento es 9.05B, que es con referente a la grama o que necesita tener grama adelante y atrás de la casa, y la ciudad dice que le va a dar 35 días adicionales y no van a ser $50 por día.
Okay. Yo ya puse semillas y está trabajando un señor, está trabajando en landscape y bueno, hay que esperar que crezca el pasto. Puse pasto pero se secó. gasté mucho dinero en poner el pasto y se secó. Y ahora lo removí porque tuve de nuevo la violación. Me pusieron una carta, lo removí y ahora puse semillas porque si pongo el pasto se seca.
He's basically saying that he understands, but he has tried putting seeds and also other live ground cover. It actually has dried, but he's actually working on it with some seeds right now, and he actually has hired a landscaper to help him out as well.
And the city concurs with that, Your Honor. Therefore, they asking for the extension of 35 days to allow the seed time to sprout.
Okay, so ordered.
Thank you, Your Honor.
El señor Jordan le va a darles 35 días para que crezca la grama que usted tiene ahí.
Ok, muchas gracias.
Gracias, Fabio.
Gracias.
Thank you.
Thank you, sir.
Thank you.
Our next case is on page 35, Inspector Patrice Jolly. Case number CE 21070951, case address 1298 Northwest 13th Court, owner 1011 Northwest 7th Avenue LLC. This property was cited on 7/30/21 to comply by 8/14/21. One section complied at $200 per day, $2,200 accrued. The city is requesting full amount and no appeal was received for the citation.
Hello, good morning, Your Honor. Inspector Patrice Jolly presenting case CE 21070951 for the property located at 1298 Northwest 13th Court. This property was first cited on July 30th, 2021 for the violation 15-272.A, operating a vacation rental without the required certificate of compliance from the city. 15 days were given to comply. This property was out of compliance for a total of 11 days at $200 per day, and no appeal was filed. The city is requesting the full imposition of fines.
Okay, sir, please state your name for the record.
Rob Morona for representing the landlord.
Say that again.
Rob Morona, representing the
Okay.
1011 Northwest.
Was an appeal filed in this case?
I don't believe so, no.
Okay, all right. No alternative but to impose the fine. Thank you.
Thank you.
Thank you, Your Honor.
Our next case is on page 18. Inspector Wanda Aquavela. Case number SE 21050236. Case address 1044 Northeast 12th Avenue. Owner Pierre and Nadine Bernard. And this is an administrative appeal.
Good morning, Your Honor. Wanda Aquavilla for the city.
Good morning.
Case and address is read. We inspected the property on 5/14/21, posted it, took pictures. We re-inspected on 5/17/21, took additional pictures, and we had it picked up on 5/18/21.
Okay, please state your name for the record.
Nadine Bernard.
Okay, and what would you like to tell me about this?
Well, actually, good morning to both of you and all of you. I'm very impressed about seeing all the women. The thing is, we messed up the month, and we always complied with the city, whatever, with the bulk trash. But this month we messed up with the month of April. And when we realized our mistake, the couch was already gone. And the notice, we saw it only a few days after the removal of the couch. And the removal was the following week. So it's a stupid mistake of us mixing up with the month. That I have no other justification.
We posted the property.
Yes, but we don't live on the property, and then, because tenants, they don't care about whatever it's on. And then, actually, we were making tour of whatever, because we pick up trash pretty much. And I don't know if you can see over the record, but the dead street, that street both sides, it's us. we always maintain pretty good the properties. And then we were making a tour, and then it's by chance that we saw the note over the building. It was like almost not visible for us easily. So, and then we thought actually that the cash was removed by people passing by. And then whatever other trash that people put on the.
It was
Yeah.
removed by us.
Okay. Anything else from the city?
No, ma'am.
Okay, I'm gonna find for the city in this case.
Thank you, Your Honor.
I'm sorry?
I'm finding for the city that they posted the property, that
Okay.
the violation existed, and that the city picked up the bulk trash.
All right, thank you.
All right, thank you.
Our next case is on page 21, Senior Inspector Leonard Champagne. Case number CE 19061120, case address 5300 Northwest 9th Avenue, owner Powerline Industrial Center. This case was first heard on 9/19/19 to comply by 12/5/19. There are 2 suspensions noted on the agenda. This property is in compliance, $34,800 accrued, and the city is requesting $847.
Good morning, Your Honor.
Morning.
Leonard Champagne again for the city. For case number CE 19061120, 5300 Northwest 9th Avenue. As stated, Your Honor, the city is requesting to reduce the fines to administrative fees or hard fees of $847.
Okay, sir, please state your name.
Michael Pizzi, on behalf of Extreme Action Park,
Okay.
and Michael Pizzi on behalf of Powerline Industrial Commerce Center and Extreme Action Park. We're in agreement, and we thank the staff in the city for their excellent cooperation. Mr. Champagne's done an outstanding job. He's a true professional. We want to commend Mr. Champagne and thank the city, and we're in agreement.
Well, we appreciate that. Thank you so much for saying that, sir. And we'll reduce to city cost of $847.
You know, people don't, I just want to, a lot of complaints here from the lawyers. I happen to think that your staff and your inspectors are very fair and thorough, and they do a great job. And if you cooperate with them and work with them, nobody will ever have a problem. And you guys do a great job. Thank you very much. Thank you, Mr. Champagne.
You're welcome. Thank you, Your Honor.
Thank you.
Our next case is on page 18, Inspector Wanda Aquavela. Case number SE 21060334. Property address 320 West Park Drive. Owners Carrie and Camille Finn.
Morning, Your Honor. Inspector Wilson Quintero Jr. on behalf of the city. Case and address as read. This property was cited on June 25th for a bulk trash violation. It was posted. Reinspection was done the 28th, and the items were removed the 29th. I have been in contact, if this is Miss Camille Finn, I have been in contact with her since the 29th. We spoke on the phone, and then we also exchanged emails. I emailed her photos and everything of what's going on. It seems as if she was unaware of what the actual violation was. She didn't contact us until after it was removed, unfortunately, but she was under the impression it was a different item on the property that was in violation and not the one that we removed, but the one that I originally cited is the one that we originally removed, so she can explain on her behalf.
Okay. Please state your name for the record.
Camille Fenn.
Okay.
So I did receive the violation on the Friday on the 25th. The tenant brought it to my attention within an hour, I would say. I immediately emailed the tenant that was parked in the back because I had seen that he had left some tires and things that were in his car on the fence. I asked him, I said, I've just received a violation from the city. I saw your tires there. Can you pick them up? He responded back to me within half an hour saying I was just putting them there. They're already gone. So I said, okay, thank you. I'll come back and double check everything. I went back on the Saturday morning, and the property is on West Park Drive, but the back of the property is on 19th Street. So I parked on West Park Drive. I drove in the back. And the way the property is set up, I looked at the entire area where we usually do our bulk trash and leave our things, and everything was fine. He had picked up his tires. I verified that everything was cleaned up, and I thought I was good. On Monday morning, I called the city, but I called the general code enforcement number, and I got according to my phone, I got too busy, or I didn't get through. And on the Tuesday morning, I called the inspector's direct number, and I left him a voicemail saying, I've gone and verified everything, the tires are gone, it's all cleaned up. By the time the inspector called me back and said, I don't know why you're talking about tires, I'm talking about palm fronds. I discussed it with my tenant. He said that he had seen the neighbor put palm fronds down, but actually the neighbor said, no, when I saw the inspector, I tried to take the palm fronds and put them in your bin or in my bin. And he also pointed out to me that these palm fronds are not even of any same species as any of the landscaping he has or I have. So we don't quite know where these palm fronds came from. There are only 4 of them laying on the ground, and perhaps that's the reason why I didn't see that when I went to double check on the property. And when we were exchanging emails, my neighbor, who was new to the area, a new homeowner, who didn't know he had a big pile, I thought that was his palm fronds. By the time the whole misunderstanding, as Mr. Quintero and I were emailing, I said, all right, let me go and pick them up then. And he said, never mind, I just had them done this morning. And according to this, that was on the 28th. So I wasn't even given the 48 hours to get these palm fronds. It says bulk trash removal charge, $240, date abated, 6/28.
So is what you're saying, they were picked up before the 48 hours was up?
When I realized that what my violation was not about these tires, and Mr. Quintero said, no, there's palm fronds, I said, all right, well, let me go and check again. And actually, he emailed me photographs, and that's when I understood why, because it's a strange property that's very pointy, and I can't, when I walk back there, you can't see around the corner because of the landscaping. So that's why and it didn't say on the violation what was there. It just said, what did it say, debris on swale or something like that. So I thought they were the tires. I see also on Nextdoor 2 days ago, somebody posted in Tarpon Bend, palm fronds dumped on my property, not cool.
Yeah, okay.
So I don't know
I know
where they
that's
came from.
That's not in front of me right now, and
Right.
I know people dump it on other people's property, but, you know, it's the property owner's responsibility, so.
But I was right on it. I didn't ignore anything. I was a property manager myself. I clean up my median where I live, where all the people leave their lunch. So I guess I'm fighting this a little bit because I try to be such an upright citizen. I don't think, I would have been glad to pick them up. And he said, oh, it's too late. I sent my guy this morning. They're gone.
Okay, anything else from the city?
No, ma'am.
Okay, I'm gonna give the property owner the benefit of the doubt here, because she seemed to have tried to be very diligent, so, and the appeal's granted.
I really appreciate it.
Thank you.
Thank you.
Thank you.
Thank you.
Our next case is on page 30. Senior Inspector Dorian Cologne. Case number CE-19120594. Case address 7 North Birch Road. Owner Los Olas Harbor Club LLC. This case was first heard on 9/9/2020 to comply by 11/11/2020. There are 3 suspensions notated on the agenda. 1 section not complied at $50 per day. $5,150 accrued. 1 section complied at $50 per day. $2,050 accrued. A total of $7,200 accrued, and this is in order to reappear. Good morning, Stephanie. Can you raise your right hand, please?
Good morning.
Good morning. Thank you. Do you swear and affirm to speak the truth at today's proceedings?
I do.
Thank you.
Thank you.
Good morning again. Senior Inspector Kaloyan for the City of Fort Lauderdale. Case number is CE 1912-0594. Case address is 7 North Birch Road. This case was originally assigned to Inspector Will Snyder, who first inspected and cited this property on 12/12/2019 for a seawall and mooring structure in disrepair. And it did come before the special magistrate and was granted an extension 4 times. Upon further research, I checked, and there is a permit that was issued on September 9th, 2021, and the city would not oppose to an extension for 189 days for completion of the work in lieu of that. I mean, not in lieu of that, and upon finding that information out. And also, we would like to enter the pictures in the document as depicted on, we would like to enter it as evidence, sorry.
Okay, it'll be received. Who's on for the property owner?
Hi, good morning. This is Stephanie Toothaker on behalf of the property owner. I want to thank the city of Fort Lauderdale. We worked with code enforcement to provide information. We do have all the permits, but there is a backup, as with everything in construction right now, on the barge that we need to actually pour the seawall. We are asking for a 189-day extension to complete the work. That's based on the availability of the barge that can actually do the seawall. It has been shored up. It is safe, and we will hopefully we won't need all that time. If the barge becomes available sooner, we will do the work as soon as we possibly can. But thank you very much.
All right, sounds good. 189.
I'm sorry, Your Honor, I'm sorry. And also, we would like them to reappear as well.
Okay.
Yes, happy to do that as well.
189 days. We'll suspend the fines during that time, and I'm issuing an order to reappear.
Thank you.
Thank you.
Great. Thank you so much.
Our next case is on page 31. Inspector Bovrig Xantis, case number CE 200508785. Case address 1135 Northwest 5th Court. Owner Graciela Sosana. This case was first heard on 6/24/21 to comply by 8/26/21. One section not complied at $25 per day. $850 accrued. The city is requesting full amount, and fines continue to accrue.
Good morning, Your Honor. Inspector Xantis on behalf of the City of Fort Lauderdale Community Enhancement. Case number CE 20050785. Property address 1135 Northwest 5th Court. This case was first heard on June 24th, 2021. The magistrate ruled in favor of the city, and the property owner was ordered 63 days to correct all violations. At this time, all violations are in compliance, and the city is requesting the full imposition of fine.
Okay, please state your name for the record.
Graciela Solsona.
Okay.
How are you? Good morning.
City is requesting full imposition of $850.
Okay, when that happened, I tried to do my best, and I talked with the inspector. They helped me a lot. But when the day was due, so the last day, I called them and I misunderstood that they say that I needed grass on the back. I cleaned everything. I did actually by myself.
Yeah, I know you had a lot of work done on the property.
I'm sorry?
I know you had a lot of different
Yes, I
violations
did. But
that had to be complied.
the people, very good people, my tenant, but they didn't understand exactly what the city says, that the maintenance of the house. I cleaned, I helped them, and then after the 26th of August, when I talked with the inspector and the supervisor, Mr. Davila.
Okay, this hearing is about the landscape and why it took, after we gave you an extension, 34 more days to complete the landscape.
But it's already complete. I put the grass on the back, and I told Mr. Davila, and he said, it's okay, go to the hearing because you have to go, and okay, and explaining what happened. I tried to get the grass that lives with trees, so no sand, and I put it. I spent a lot of money in that, and I talked with him, and he said that was okay. So I think it's okay now. Is Mr. Davila here, or I can talk with him?
Okay.
So what I want, if you can
Okay,
give
what-
me remove the fine, because I spent $3,000 in grass, and I have to go to water that because my tenant doesn't do that. So I go every 2 days and water, because if not, I lose my money, you know.
Okay,
So,
all right. Anything else from the city?
Julio Delaco, compliance supervisor. I did speak with her, but just to clarify, what I confirmed was that, yeah, compliance has been met, and to come to the hearing to try to state your case, and that you had the opportunity to speak with the magistrate.
yeah. Thank you. You are Mr. Davila? Hello. I always buy phone.
Your Honor, I believe it's at the best interest for property owner to just go ahead with the fine to be imposed. If we do administrative fine, it will be $996.
Say that again?
If we do the administrative fines, the number will comes out to be $996.
Oh, okay, all right. So you're being fined less than the city's costs?
The city cost? You
City's
say?
costs are over 900, and they're willing to take just the fines of 850, so that's what he's
He say
telling.
that I have to pay $800? That I have to pay $800?
$850.
Also, it was a couple of days after the time that the city gave me, and I did my best. It's a lot of money, so if I have no choice, but believe me that I work with my hands. I put the grass. I spent $3,000, and it was when I talked with the inspector and supervisor. Was a couple of days after, and said you have to go to the hearing, even if it's corrected before the time of the hearing or after the time that you gave me was on the 26th of August, but I did on September, the first days of September. Was not a long time. I don't know what is charging me for 1 month. I don't know. And
Okay, anything else from the city?
so I hope, and I ask for help, please.
No, I didn't have it here. Your Honor, the city would like to recall the numbers earlier from the administrative costs, which will be $709.
Okay. All right, $709, which is less than, the city costs are $709?
$709.
Okay.
The cost of what? I'm sorry. To go and see, and the cost of the city are $700?
The city's costs are $709. The fines are $850.
How do you estimate, sorry, but how do you estimate the fines? Like every day, $25?
Yes,
or?
they were.
Okay, but
It was $25 a day, and it took you 34 days
It was not
beyond
34
beyond
days.
the extension.
The due date was on 26th of August. On the 10th of, I don't remember exactly, but it was not 30 days. But they say that they take, I have to come to the hearing, so if you count from the
Okay,
26th.
All right, I'm going to reduce the fine to $500.
It's a lot, I can't pay that.
Thank you very
Sorry.
much.
I can pay in some monthly
You'll get
payment.
an order in the mail.
Thank you, Your Honor.
Thank you.
Our next case is on page 7. Inspector Evan Oakes. Case number CE 21050953, case address 1131 Northeast 6th Avenue. Owner, Fonor Joseph. Property posted 9/4/21. Posted at City Hall 9/16/21.
Good morning, Your Honor. Code Compliance Officer Evan Oakes, City of Fort Lauderdale Community Enhancement, presenting case number CE 210500953, property address 1131 Northeast 6th Avenue. This property was initially inspected on May 28, 2021, and the following violations were observed. 18-20 12A, there is overgrowth of grass, plants, weeds, trash, and debris on this vacant fenced lot. 9-305B, the landscape at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover. 47-21.9.m is complied. 9-280H1, the chain link fence at this property is in disrepair and is not being maintained as required. There are multiple bent fence posts and the chain link is not taut at the top and bottom. Subsequent inspections were conducted, including a pre-hearing inspection on Saturday, September 25th, 2021, and the following violations remain. 18-12A, 9-305B, and 9-280H1 as depicted in the photos. The city is requesting 21 days to comply or a fine of $25 per day per violation thereafter to be imposed.
Good morning. Can you please state your name for the record?
My name is Fano Joseph.
Are you in agreement to bring the property into compliance within 21 days?
Yes.
Okay, thank you so very much, sir. And don't, make sure you do that because after that, a $25 fine per day will start to accrue. So you have 21 days with no fines to fix the property.
Well, it's supposed to be done already because I have, once I received the notice, I have sent a contractor over there to do it. But he did some section, he didn't do the rest. And I can call him now. He will tell me, I'm on my way. I'm on my way. He never showed up. So until I spoke to them, I think yesterday, I drove by the property, still not done. When I call him up, I'm on my way. I'm on my way. This morning, I went by the place again, same thing. He never showed up. So I'm hiring a different contractor.
Good
to get it
idea.
done.
Good idea. There's some undependable contractors out there. So thank you very much.
Thank you very much.
Thank you, Your Honor.
Thank you.
Our next case is on page 32. Inspector Bovary-Xantis. Case number CE 21030814, case address 1719 Northwest 18th Street. Owners, Bernard Jackson and Christine Jackson. This case was first heard on 6/24/21. To comply by 8/26/21, one section not complied at $50 per day, $1,700 accrued. The city is requesting full amount and fines continue to accrue.
Good morning, Your Honor. Inspector Xantis on behalf of the City of Lauderdale Community Enhancement. Case number CE 21030814, property address 1719 Northwest 18th Street. This case was first heard on February 25th, 2020, and the magistrate ruled in favor of the city, and property owner was ordered 63 days to comply with all the violation. In this case, I'm sorry. I do apologize. I get the wrong. Sorry about that. Case and address as read. This case was heard on June 24, 2021. Magistrate ruled in favor of the city, and property owner was ordered 63 days to correct all violation. At this time, property remained in violation. The city is requesting the full imposition of fine.
Okay. Sir, please state your name for the record.
My name is Bernard Jackson.
Okay, Mr. Jackson, it appears that you've complied a lot of the violations, but there's still one remaining. Why is it taking so long to remove the outdoor stuff that's on the property?
What outdoor stuff? I don't understand that.
The outdoor storage are shown on the pictures. And last time we met at the properties, and I showed.
Okay. Ma'am, that is the frame I was putting up, right? Because I have a lot of grandkids. So I built up a frame to have it covered properly, right? But that is, that can come down because I have a canvas made for make a roofing for it. Right? I have a canvas made for roof, proper roofing. It's just something I build, so when my grandson come over, we all can go on and eat and relax, and we can talk or play game, anything like that. But that was just temporary covering a house.
But this says that there's plywood, buckets, boat parts, all of that being stored on the property.
Well, both parts, well, the buckets and them, you know what I mean, stuff I have inside of them.
Yeah, but you have to decide.
Okay.
Because they're in violation of the code.
Okay, man. Then I'll just excuse the buckets and them. But the covering over that, I can't take that off because I have a proper covering. Can I use that get a proper covering over my stuff that I can? It's something I make like a canopy, right?
Your Honor, it was explained to Mr. Jackson that the canopy needs to be removed as well, but this was not being cited. That was just a courtesy that was given to him as I spoke with him and let him know that I have spoke with the zoning supervisor, Mr. Bedford, that he needed to get that removed. And as I said, it wasn't cited for. But in regards to the outdoor storage, it was explained to Mr. Jackson that these stuff needed to be removed from the property.
Outside storage.
The plywoods, the buckets, all these things, including the miscellaneous items that you have sitting outside, they need to be removed outside.
Okay.
All right, I'm going to give you 10 days to pick up this property the right way. Get rid of the buckets, get rid of the plywood, get rid of all of that stuff. And so you do not get another violation, you're going to have to get rid of that canopy as well. But that's not going to be in this order because that's not in front of me yet, okay?
Okay, well, the canopy.
All right, sir.
All right.
Thank you, Your Honor.
Thank you, ma'am.
Thank you.
Our next case is on page 36. Inspector Patrice Jolly. Case number CE 21070869. Case address 1315 Northeast 14th Avenue. Owner Patrick Ceres. This property was cited on 7/23/21 to comply by 8/7/21. One section complied at $200 per day. $1,200 accrued. The city is requesting full amount and no appeals received for this case.
Good morning, Your Honor. Inspector Patrice Jolly presenting case CE 21070869 for the property located at 1315 Northeast 14th Avenue. This property was cited on July 23rd, 2021 for the following violation. 15-272.A, operating a vacation rental without the required certificate of compliance from the city. 15 days were given to comply. This property was out of compliance for a total of 6 days at $200 per day, and no appeal was filed. The city is requesting the full imposition of fines.
Good morning, sir.
Hi, good morning, Your Honor.
What's your name?
My name is Patrick Series.
Okay, Mr. Series, did you file an appeal in this matter?
No, ma'am. When I, when I received the notice, I was out of town, and I went ahead and removed the listing from Airbnb, and I have a record of documentation. It seems that the letter here says the compliance date was August 26th. Can I ask how you obtained the compliance date? Because that's not the date that I removed.
The compliance was actually, when we do the initial, I post a citation, the procedure for us, I post, and the cases are usually complied by Senior Inspector Champagne. Give me a second. I'm asking him to have him come up to speak for a second.
Okay.
Didn't review any of it, I just read it. You can read it.
I can just look it up.
Yeah. Okay, hold on. Okay, excuse me, Your Honor, can we just recall this? Just want to look over the case really quick.
Sure. Can you give them a minute, sir? I'm sorry for the
Okay, come
wait.
on.
Our next case is on page 35. Inspector Gail Williams. Case number CE 21060904, case address 2616 Delmar Place, owner Stephen Howell. This property was cited on 6/29/21. To comply by 6/30/21, one section complied at $250 per day, $1,250 accrued, and the city is requesting full amount, and no appeal was received for this case. The respondent is in the hearing room, in the Zoom hearing room.
Good morning, Your Honor. Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE.
Hold on one second, Ms. Gail, we're waiting on the respondent to get into the room.
Okay.
Good morning, Mr. Gordon.
Good morning. Good morning.
Good morning. Can you raise your right hand, please?
Yes,
Do you swear and affirm to speak the truth at today's proceedings?
I do.
Thank you.
And I'm sorry, I missed the initial presentation. It was switching over to the conference, and I did not hear some of the things that were said.
No worries, I have no problem rereading it for you. So the case number is CE 21060904 for 2616 Delmar Place. The property was cited on 6/29/21 to comply by 6/30/21. One section complied at $250 per day, $1,250 accrued. The city is requesting full amount, and no appeal was received for this property.
Good morning. Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 21060904, address 2616 Delmar Place. On June 29, 2021, the following violations were cited and a citation issued for violation 18-1. There are trash overflowing trash containers and trash on the ground and property. In this condition, it creates a public nuisance in that it adversely affects and impairs the economic welfare of the adjacent properties and may become infested and inhabited by rodents or other vermins. No appeal was received or filed for this case. As of July 6, violations have complied. The city is requesting full amount to be imposed.
Okay, sir.
Yes, ma'am. I had spoken with Ms. Williams, and there was
Say
a
your name for the record.
sure Brent Gordon on behalf of the homeowner Stephen Howell.
Okay, and did your client file for an appeal within
No,
14 days?
No, ma'am. Although I believe the citation says 15 days,
15 days, sorry.
but no, he did not.
Okay, all right. You can tell me what you want to make your record, but I'm going to tell you what I've told everyone else.
Sure, and I won't waste Your Honor's time with arguing the merits of all of this. I certainly understand the position that Your Honor is in. The only thing I would say is just I think as far as compliance, the notice of hearing and as on the docket today is quite different than the description on the actual violation, and so I think there's a real question as to what actual compliance was. And whether or not the fine should have continued accruing during that time period. If you look at the notice, it references excessive accumulation of items stored in the front porch enclosure of this property. In this condition, it creates a public nuisance in that it adversely affects and impairs the economic welfare of adjacent properties and may become infested or inhabited by rodents or other vermin. The pictures reflected show trash outside, but they don't actually reference or show any accumulation of items in the porch. So I think there's a real question as to what the issue was with compliance. So while my client would not have any objections to addressing this violation, I don't know that there was a clear understanding of what that violation is supposed to be according to the city.
Okay.
So we would ask that the fine be put in at the initial amount that was noted, which is $250, or it treated as contested as $325, and happy to get that paid in short order.
Okay. Unfortunately, everything is deemed admitted and notice issues are waived as well. So I'm going to have to impose the fine. And obviously, you have other options with lien reduction and whatever.
Fair enough.
Thank you, sir.
Thank you very much. I appreciate it. Oh, Your Honor.
Yes.
Sorry. And so just as far as the city is concerned, once this amount is paid, is the case closed out?
When it's paid, it's
Yes.
closed out. Yes.
Yes.
Okay. All right. Very good. Thank you very much.
Thank you.
All right. Take care. Bye-bye.
Your Honor, we're recalling the case on page 36 for Inspector Patrice Jolly, case number CE 21070869 for 1315 Northeast 14th Avenue.
Good morning, Your Honor. Inspector Patrice Jolly presenting case CE 21070869 for the property located at 1315 Northeast 14th Avenue. The property was cited on July 23rd, 2021 for the following violation: 15-272, operating a vacation rental without the required certificate of compliance from the city. As we just went over it and checked and did some more research on the case, it seems that the listing was taken down, so the city is going to comply the case with no fines.
Okay, sir, state your name again for the record. Okay, I'm assuming you'll agree to no fines.
I think I'll agree to that.
Thank you, sir.
Thank you.
Our next case is on page 40 with Inspector Evan Oakes. Case number CE 210507110, case address 1016 Northeast 17th Street, owner Little Palms Academy LLC. This case was first heard on 8/26/21 to comply by 9/30/21. Fines are due to start on 10/1/21, and this is a request for an extension.
Good morning, Your Honor. Code Compliance Officer Evan Oakes for the City of Fort Lauderdale Community Enhancement, presenting case CE 210507110, property address 1016 Northeast 17th Street. The case was first heard on August 26, 2021. The magistrate ruled in favor of the city, and the property owner was ordered 35 days to correct all violations. A pre-hearing inspection was conducted on September 25th, 2021, and revealed the following violation remained as depicted in the photos. 47-20.20.H. The parking facilities are not maintained at this property as the asphalt is cracked, the curbs and striping are deteriorated, and there are areas where water is pooling. Fines are scheduled to start on 10/1/2021, and the property representative would like to request an extension.
Okay, please state your name for the record.
Giovanna Gonzalez.
Okay, it looks like you've complied most issues, but we still have the parking facility as an issue. How much time are you asking for?
We're just waiting on the permit. It came back and needed some changes, and we resubmitted it, so we're just waiting on it. And as soon as we get it, we'll start.
All right, any objection to further extension?
No objection, Your Honor, and the permit was applied for on August 31st.
Okay, all right, so how much time do you think she needs?
We're not opposed to granting an extension of 35 additional days.
Okay. Okay, I'll grant the extension of 35 days. If for some reason you don't get the permit or there's a problem, make sure you contact the inspector.
Okay, I will.
Thank you.
All right,
Thank you, Your Honor.
Our next cases are on pages 11 and 12 for Captain Robert Krasarwich. On page 11, case number FC 2108 0013. Case address 5950 Northwest 28th Way, number C8. Owner, City of Fort Lauderdale, in care of the Fort Lauderdale Executive Airport. And on page 12, FC21080017. Case address 5950 Northwest 28th Way, number C10. Owner, City of Fort Lauderdale, in care of the Fort Lauderdale Executive Airport. Good morning, Mr. Rowe. Can you raise your right hand? Do you swear and affirm to speak the truth at today's proceedings?
Yes.
Thank you.
Good morning, Your Honor.
Morning.
Captain Robert Kasarowicz with Fort Lauderdale Fire Marshal's Office. Presenting case FC 21080013. Property address of 5950 Northwest 28th Way, Unit C-8. Property was cited in reference to NFPA 101, 43.7.2. There's been a change of use that requires a permit, storage used as industrial occupancy. These are aircraft storage hangars that are being currently used for maintenance that are in there, which is an industrial use. We've been working with the city's leaseholder on this property in order for them to get their tenants to bring this property into compliance. They're very cooperative, and they're going to have to file and go through an eviction process on this. So at this point, we will request 70 days to come into compliance in order for that process or a lockout to take place to bring the property into compliance, or $100 a day thereafter.
Okay. Who's here for the property owner?
Tom Rao with Lynx FBO.
Okay, are you in agreement with 70 days or $100 a day thereafter?
Yes, I am.
Okay, thank you very much, sir.
Thank you.
For the next case, that's going to be FC 21080017 with a property address of 5950 Northwest 28th Way. That's Unit C-10. That unit was also cited in reference to NFPA 101, 43.7.2. There's been a change of use that requires a permit. Keep the consistency in this. It's the same situation. We're requesting 70 days or $100 a day thereafter.
Okay. Sir, you still with me?
Yes, I'm in agreement with that.
Okay, thank you very much.
Thank you.
Thank you.
Our next case is on page 11. Inspector Gustavo Caracas, case number CE21070957, case address 2120 Northwest 21st Terrace, numbers 1 and 2. Owner Pico Turquino Investment LLC. Property posted 9/7/21, post at City Hall 9/16/21.
Good morning, Your Honor. Mr. Rigo, thank you for your patience.
Thank you.
Gus Caracas for the City of Fort Lauderdale Code Compliance Inspector, presenting case number CE 21070957 for the property located at 2120 Northwest 21st Terrace. Inspection of the property was performed on July 27, 2021, and cited for the following violations. 47-20.20.H. The parking facility is not maintained at this property. Resurfacing and restriping is required. 18-12A, there's trash, rubbish, and debris on the property and on its swale. 18-1, there's outdoor storage of miscellaneous personal goods on the north side of this property, thus creating a public nuisance. Is being maintained in such a manner that the property is or may reasonably become infested or inhabited by rodents, vermin, or wild animals, or may furnish a breeding place for mosquitoes, or threatens or endangers the public health, safety, or welfare of many, or may adversely affect or impair the economic welfare of the adjacent properties. Inspection report was actually posted on the property and mailed to the property owner as listed on BCPA via first-class mail on July 27, 2021, allowing 10 and 30 days to come into compliance. Contact has been made with the property owner representative. Special master hearing notice mailed to the property owner September 1st of 2021. Pre-hearing inspection was done on September 27th, and the pictures presented here were taken to confirm the violations have not been brought into compliance. City is requesting the following: 35 days to come into compliance, or a daily fine of $50 for each of the violations that exist. Photos were submitted into record for evidence. The president of the property is here to speak.
Sir, please state your name.
My name is Humberto Rego.
Okay. Are you, is this your property? Are you president of this company?
Yes, I'm a manager of that company.
Okay, all right. Are you in agreement to bring the property into compliance within 35 days?
Yes, Your Honor.
Okay, thank you very much.
Thank you, Your Honor. Thank you, sir.
Our next case is on page 27 with Inspector Gustavo Caracas. Case number CE 19081100. Case address 666 West Broward Boulevard. Owner Burger King Corp. number 43 in care of Ryan. This case was first heard on 1/16/2020. Page 27.
Sorry about that. Okay, go ahead.
There are 3 citations notated on the agenda. 4 sections not complied at $250. $130,000 is accrued. 1 section complied at $250. $17,250 accrued. A total of $147,250 accrued. The city is requesting full amount and fines continue to accrue. Good morning, Mr. Lobello.
Good morning.
Hi, can you raise your right hand?
Yes, ma'am.
Do you swear and affirm to speak the truth at today's proceedings?
I do.
Thank you.
Good morning, Your Honor. Inspector Caracas, case and address number, as read on record. I believe the property owner or the business owner is here to ask for more time. As this time, ma'am, as you can see on the pictures, the violations have not been brought into compliance.
Okay. Where's the property owner?
I'm on the internet, ma'am.
Okay. Do you have your video turned on, or are you joining me by phone?
I'm not sure how to turn the video. I could do that if somebody would oh, wait, start video?
Yes.
There we go.
Okay, thank you.
No worries.
Yes, this has been going on since January of 2020. And it looks like you complied a few things, but, I mean,
Your Honor, if I may.
well, go ahead.
We straddle a county street as well as the city street. And so there's been the city of Fort Lauderdale has been working with us. We still have a permit in the county because they want, we're going to be closing 2 of the approaches. We're to the north of the restaurant and to the east of the restaurant. We're taking out all of that parking. That's going to be new landscaping. It's going to be, everything's going to be brand new. And the swale in the back is because of a failed pool for the sewer. And so that pool right there in that picture. And so we're still in permitting. They keep rejecting our lift station. And we're on our 3rd rejection of that lift station, and they won't give us the proper specs to give to a company. So we keep trying to get different specs out to them. We have not, again, received that. That's why the parking lot has not been finished up. The parking lot in between the drive-through area has been, the potholes have been filled, and they're doing an overlay as we speak. They've been having issues with rain delays, as well as the back area. We had a contractor that we tried to do a change of contractor on, and the city refused it because he said that he was working through it. And it's been 1.5 years since that date. That was in January. We were told that October 1st we could reapply if he did not do any work. So we're reapplying tomorrow to change the contractor to get the finished work done on the back part of the building. And hopefully the city will approve.
Your Honor, as you see, this case has been going on for quite some time. I can tell you that the the business owner is trying to work with the county and with the city. There is some sort of boundary lines or overlaying of properties. So he's in the middle of everything. He's trying to do his best, but he can't do anything until one side or the other side actually concurs. So I do not oppose, the city does not oppose to a stay of fines and give him at least 6 months to continue and see where this actually leads, and also bring him back to see where he's at with this situation, ma'am.
Okay. All right, okay, unfortunately, I don't have a hearing date on here to bring them back.
Your Honor, I've also submitted all the documentation from the county to Officer Caracas, and he has been in reference, he has gotten all that from the county as well as the holdups.
Okay, all right, I'm gonna give you 182 days and in order to reappear, and you'll tell him when he needs to reappear close to that date. All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Officer Caracas.
You're welcome, sir.
Am I dismissed?
Yes, you're excused.
Thank you.
Thank you.
Our next case is on page 23. I'm sorry, next two cases are on page 23. Case number CE 180708838. Case address 2631 Southwest 12th Terrace. Owner Beth Brooks, Tammy Brooks, and all others. This case was first heard on 11/15/18 to comply by 2/14/19. There are 4 suspensions notated on the agenda. One section not complied at $50 per day. $15,750 has accrued. The second case is case number CE 1712130. Case address 2631 Southwest 12th Terrace. Owner Beth Brooks, Tammy Brooks, and all others. This case was first heard on 6/7/18 to comply by 9/6/18. There are 5 suspensions notated on the agenda. One section not complied at $50 per day. $12,600 accrued. The city is requesting full amount fines continue to accrue. Ms. Brooks, can you please raise your right hand? Do you swear and affirm to speak the truth in these proceedings?
Yes.
Thank you.
Good morning, Your Honor. Inspector Emmons, 311 for the City of Fort Lauderdale, presenting for the case and property as read. The first case I'll speak of is CE 180708838. This violation was first cited on 7/11/2018 by the previous inspector. This case first came before the special magistrate on 11/15/2018, where evidence was presented by previous inspector Sanguinetti, and the magistrate found for the city for the following violation, 9-306. Since then, there have been 364 days of extensions given. There have been conversations with the property owner about the violations. This property was inspected for this hearing on 9/25/21, and the violations remain. The fines continue to accrue. It is the position of the city that fines be imposed as read.
Okay, Ms. Brooks? Hello? Is the property owner?
Hello?
Yes.
Yes.
Okay. This has been going on since, for 3 years now, and doesn't look like there's anything been done to this property. What's going on?
I am working with Rebuilding Florida to replace the entire house. This was done, Hurricane Irma completely destroyed the house, and it's going to be torn down and rebuilt. Right now, they're in the end of the planning stages. They're going to go into permitting, and construction should start shortly, hopefully. Rebuilding Florida has been in touch with both Inspector Carroll and Inspector Emmons, stating the fact. I had given previous Inspector Sanguinetti several documents to this effect. in front of the magistrate on several hearings. Every time we had a hearing, I gave them documentation, proof that I'm working with Rebuilding Florida. I definitely have the grant. They're definitely going ahead with it, but it is a federal situation, and they take their time.
And what extension?
And I started working on this as soon as the hurricane, before it was even over, I started working on this project. I applied to FEMA, I applied to Rebuilding Broward, I got through to Rebuilding Florida, and it's, I've had, it's been in the works. In fact, they were supposed to start like this month, but it's just, I'm on the phone with them every day. They have me in temporary housing now, and I'm sure they want to get me out of that and into my house as soon as possible. But the whole thing is going to be replaced. I am an elderly, a 70-year-old widow, on disability. I had a drunk driver break my neck. It's not like I could have done anything myself about this. I did pay my taxes. I do keep the lawn mowed. I do as much as I can.
And how much time are you asking for?
I'm asking for at least another 90 days.
And did you say that this was part of a federal grant program?
Yes, it's part of Rebuilding Florida. That's correct. And my case number with them is 000436.
Okay. And did you receive that grant money?
I received that grant in May of 2020.
Okay, so why is it taking so long?
And they tried to repair the home first, but the building department turned down the permits because they said the house has to be torn down. And rebuilt. Also, the land's too low because of the flood thing, so they won't repair. The building department will not give any permits for repair work done on something that's too low. So that's why it has to be completely replaced.
Okay. And when was this received? Date on it.
And that documentation should be in my file. I handed off to Inspector Edmonds some letters from Rebuilding Florida to the feds. Like I said, he spoke with the construction team from Rebuilding Florida, and they also spoke to Inspector Quintero just last week about this. They also called the city attorney. They've called several people. They are definitely going to take care of this problem because I am on a government program here.
Okay. When did you receive the notice that you were awarded the grant?
They received that, I believe, in February of this year.
Okay. And so
They turned them down for the permits.
okay, and you applied for the permits when?
No, the construction company did. It was Westfield Construction, and the guy's name is Brendan Day. They're from Pembroke Pines.
Okay.
And then they determined they could not repair the building. It has to be torn down.
Okay. So did you apply for a demolition permit?
I believe they are going to be applying for a demolition permit any day now. And because it only takes a day to demolition it. So as soon as they get the demolition done, it takes a day, then they'll start right on the construction.
Okay. All right. Anything else from the city?
I was told they have to get the demolition permit along with the other permits. They're going to do it all simultaneously.
Your Honor, we're not opposed to an extension. I didn't know if you wanted me to read the other case number in to get that on record.
Yes, I think she read both case numbers, and I'm hearing them together.
Okay, that is fine. And I have been in communication with the property owner, and she has given me documentation from Rebuild Florida that's in the case file. So we're not opposed.
All right, 91-day extension, ma'am.
Thank you.
You're welcome.
Thank you, Your Honor.
Are there any respondents in this room that are not here for lien reduction? So everyone present is here for lien reduction? Okay.
Okay, sounds good.
We're going to take a 5-minute recess. Our next case is on page 1. Senior Inspector Wilson Quintero, case number CE 21080016, case address 2340 Northwest 15th Court. Owners JD and Alice Bradley, property posted 9/9/21, posted at City Hall 9/16/21.
Good afternoon, Your Honor. Senior Inspector Quintero, Senior number 269 on behalf of the city. I'm presenting case number CE 21080016 for the property located at 2340 Northwest 15th Court. I first inspect this property on 8/2/2021, following a department team project on the Dillard Park District 3 neighborhood. The following code violations were observed and cited. 47-34.1 point capital A point 1 point. There is an illegal land use occurring at this RSA zone property. There is a refrigerator and other non-permitted items stored at the east side of the property under a car canopy, which is not a permitted land use in RXA zoning per ULDR table 47-5.11. 9-280H1, the chain link fence at this property is in disrepair and is not being maintained as required. There are sections of the fence that are bent and damaged at the east side and west side of the property, facing the adjacent properties and are in need of maintenance. The posting, mailing, and legal document has been done by department protocol. There has been no contact with the property owner or residents, and no one called the office of the inspector. The BCPA reveals is not change in the ownership, and the property is not homestead. A pre-hearing re-inspection of the property last Tuesday, 9/28/2021, reveals that violations remain as depicted in the electronic file pictures. The city is recommending 28 days to come into compliance and $50 a day thereafter for each violation.
So ordered.
I'm submitting the case history for evidence, Your Honor.
Our next case is on page 2. Inspector James Fetter, case number CE 21080075, case address 2320 Northwest 15th Court. Owner Johnny L. Davis, property posted 9/2/21, posted at City Hall 9/16/21.
James Fetter for the City of Fort Lauderdale, presenting case CE 21080075, property located at 2320 Northwest 15th Court. Inspection was done on 8/3/2021. The following violation was cited. 9304B, the gravel driveway in this occupied property is not being maintained. There are areas of the gravel driveway that have grass and weeds growing through it. The driveway is not well graded. An inspection report was issued allowing 30 days to come into compliance. No contact was made with the property owner. The inspection report was posted on the property. A re-inspection of the property was done on 8/25/2021. I found the violations remained as depicted in the photographs, and the city is requesting 35 days and a fine of $25 for the violation, and I would like to submit the case file to the court.
Okay, so ordered.
Thank you.
Our next case on page 3 is a stipulated agreement. Case number CE 21060815, case address 1601 Northwest 7th Avenue. Owner Elsa Holdings LLC in care of Stephen M. Arbacher. Inspector Paulette Del Grasso. The property was posted on 9/7/21 and posted at City Hall on 9/16/21. For violation 18-12A, 10 days or $25 per day thereafter. Violation 9-306, 126 days or $25 per day thereafter. For violation 9-308A, 126 days or $25 per day thereafter. Violation 9-304B is complied. Violation 9-280H1, 126 days or $25 per day thereafter.
Okay, so ordered.
Our next case is on page 4, Inspector Brian Lopez. Case number CE 21040982, case address 844 Northwest 18th Avenue, numbers 1 and 2. Owner Nellie Mar LLC, property posted 9/23/21, posted at City Hall 9/16/21.
Good afternoon. Brian Lopez, Co-Compliance Officer for the City of Fort Lauderdale, presenting the aforementioned case and corresponding property. Co-Compliance Officer Linda Holloway inspected the property on May 3rd, 2021, and issued an inspection report for the following violations: 18-12A, 9-306, 9-304B, 9-305B, 24-7B. And re-inspected the property on September 23rd, found the violation 9-306, 9-304B, 9-305B remain. City is requesting 35 days to comply or a daily fine of $25 per day thereafter.
So ordered.
Our next case is on page 5, Inspector Brian Lopez. Case number CE 21050. 050861, case address 501 Northwest 8th Avenue. Owner Andrew Jimenez, Revocable Trust. Andrew Jimenez, trustee. Property posted 9/23/21, posted at City Hall 9/16/21.
Brian Lopez, Co-Compliance Officer for the City of Fort Lauderdale, presenting the aforementioned case and corresponding property. Co-Compliance Officer Linda Holloway inspected the property on May 28, 2021, and issued an inspection report for the following violations: 47-21-9.m, 9-305A, 47-34.1.A.1, 47-19.1.c, 18-18A. We inspected the property on September 23rd, 2021. I found the violation 9.m remains. The city is requesting 15 days to comply or a daily fine of $50 per day thereafter.
What, say that again. How many days?
Oh, I'm sorry, 15 days
15 days? Or,
to comply or a daily fine of $50.
yeah, we have to do 14 or 21 by our calendar, so,
Okay, 14 then.
okay. So ordered.
Our next case on page 5, Inspector Boverick Xantis. Case number CE 200-20154. Case address 1212 Northwest 19th Court. Owner Francis Powell. Property posted 9/16/21. Posted at City Hall 9/16/21.
Good afternoon, Your Honor. Inspector Xantis on behalf of the City of Lauderdale Community Enhancement, case number CE 20-0201 54. Yeah, 0154, property address 1212 Northwest 19th Court. Property was first inspected in February 8, 2020, and the following violations were observed. 18-4C is complied. 47-34.1.A.1 is complied. Violation 9-304B, the gravel driveway is on this occupied property is not being maintained. There are areas of the gravel driveway that are missing one through, and there's grass going through it. Notice of hearing was posted on property on September 16, 2021, and a pre-hearing inspection was conducted on September 24, 2021, revealed the violation remains as depicted on the photos. The city is requesting 35 days to correct the violation or a fine of $50 per violation for each day thereafter.
So ordered.
Our next case is on page 6. Inspector Michael Jordan, case number CE 2104037. Case address 1713 Southwest 5th Street. Owner Thomas E. Forrest. Property posted 9/1/21, posted at City Hall 9/16/21.
Good morning again, Your Honor. Officer Michael Jordan for the city. Case number and property address as read. This is an RD 15 zone residential property. On April 6, 2021, a property was inspected. As a result of a neighbor complaint, was issued a notice of violation for the following: 9-304B, driveway maintenance and parking. There are vehicles and trailers parked on the grass lawn area. This is complied. 47.34.1.A.1, illegal land use occurring at this property. Residents doing mechanical work on boats, unroofed, non-permitted storage of mechanical equipment parts visible from the right-of-way, which is a non-permitted land use. This is complied. 4734B1, overnight parking of derelict vessels, boats, and trailers on the property. This is also complied. Property was re-inspected multiple times. The property owner was present earlier and satisfied with the city's request. City's requesting a finding of fact that the violations existed.
So ordered.
Thank you.
Our next case is on page 7. Inspector Michael Jordan, case number CE 2105090, case address 1709 Southwest 5th Street. Owner Michael Tierney. Property posted 9/1/21, posted at City Hall 9/16/21.
Again, Officer Jordan for the City of Fort Lauderdale Code Compliance Division, case and property address as read. This is an RD15 zone residential property. On May 21st, 2021, property was inspected as a result of a neighbor complaint. Was issued a notice of violation for the following. The landscape of this property is not being maintained in a neat and well-kept appearance. Areas of dead and missing ground cover apparently caused by vehicles parking on the lawn. Property's been re-inspected multiple times from the notice of violation. As of the pre-hearing inspection, property remains in violations with reference to this case. The property owner has not been in communication with the inspector to date. City's requesting 35 days to comply, $50 per day thereafter.
So ordered.
Thank you.
Our next case is on page 8. Inspector Evan Oakes, case number CE 210700233, case address 1336 Northeast 5th Avenue. Owner 1336 Blue Ribbon Properties LLC. Property posted 9/4/21, posted at City Hall 9/16/21.
Good morning, Your Honor. Code Compliance Officer Evan Oakes, City of Fort Lauderdale Community Enhancement, presenting case CE 210700233, property address 1336 Northeast 5th Avenue. The property was initially inspected on July 8th, 2021, and the following violations were observed. 9-305B, the landscape at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover. 9-304B, the driveway parking area is not being maintained in a smooth, well-graded condition. The driveway is faded, has excess cracks and low-dipped areas that collect standing water. 9-306, the exterior building walls have not been maintained. Structural parts, including fascia and soffits, are in disrepair. There are areas of the exterior that have stains and missing peeling paint. Subsequent inspections were conducted, including a pre-hearing inspection on Saturday, September 25th, 2021, and the following violations remain. 9-305B, 9-304B, 9-306 as depicted in the photos. The city is requesting 35 days to comply or a fine of $25 per day per violation thereafter to be imposed.
So ordered.
Our next case on page 8, Inspector Evan Oakes, case number CE 210700394, case address 1725 Northwest 6th Avenue. Owner Shimon Buttle. Property posted 9/7/21, posted at City Hall 9/16/21.
Code Compliance Officer Evan Oakes, City of Fort Lauderdale Community Enhancement, presenting case CE 210700394, property address 1725 Northwest 6th Avenue. The property was initially inspected on July 14th, 2021, and the following violations were observed. 9-305B, the landscape at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover. 18-12A, complied. Subsequent inspections were conducted, including a pre-hearing inspection on Saturday, September 25th, 2021, and the following violations remain. 9-305B, as depicted in the photos. The city is requesting 35 days to comply or a fine of $25 per day per violation thereafter to be imposed.
So ordered.
Our next case on page 8, Inspector Evan Oakes, case number CE 210600347, case address 1722 Northwest 8th Court. Owner Uzara Jara LLC. Property posted 9/13/21, posted at City Hall 9/16/21.
Code Compliance Officer Evan Oakes, City of Fort Lauderdale Community Enhancement, presenting case CE 210-60347. Property address 1722 Northwest 8th Court. This property was initially inspected on June 10th, 2021, and the following violations were observed. 9-280B complied, 9-280H1 complied, 1812A, there's overgrowth, trash, rubbish, and debris on the property and/or its swell. The landscaping is growing into the fence as well as the swell. Subsequent inspections were conducted, including a pre-hearing inspection on Saturday, September 25th, 2021, and the following violations remain. 18-12A as depicted in the photos. The city is requesting 14 days to comply or a fine of $25 per day per violation thereafter to be imposed.
So ordered.
Thank you, Your Honor.
You're welcome.
On page 10, case number CE 210500038 has been withdrawn. Our next case is on page 12. Captain Robert Krasowicz, case number FC 210800026. Case address 1301 Northeast 6th Street, owner Aveline LLC, property posted 9/13/21, posted at City Hall 9/16/21.
Good afternoon, Your Honor. Captain Robert Desarwich with Fort Lauderdale Fire Marshal's Office. Case number FC 210800026 with property address 1301 Northeast 6th Street. The property is cited in reference to NFPA 1, 13.6.4.3.2.1. The fire extinguishers have not been serviced or tagged by a certified person or company within the last 12 months. We're requesting 28 days or $100 a day thereafter.
Okay, so ordered.
Our next case on page 12, case number FC 210800027, case address 1141 Southeast 6th Terrace, owner SNP Trust Holdings LLC, property posted 9/13/21, posted at City Hall 9/16/21.
And Captain Robert Desarwich with Fort Lauderdale Fire Marshal's Office for case number FC 210800027 for the property address 1141 Southeast 6th Terrace. Property was cited in reference to NFPA 1, 13.6.1.2. The fire extinguishers are not provided in accordance with the code. I have been in touch with property management on this, and the violation should be corrected by the end of the week. We're requesting 28 days or $100 a day thereafter.
Okay, so ordered.
Our next case is on page 14. Inspector Bover-Xantis. Case number CE 210200640. Case address 514 Northwest 15th Way. Owner Golden Heights Church of Christ, Inc. Property posted 9/16/21. Posted at City Hall 9/16/21.
Good afternoon, Your Honor. Inspector Xantis on behalf of the City of Fort Lauderdale Community Enhancement. Case number CE 21020640. Property address 514 Northwest 15th Way. Property was first inspected on February 18, 2021. Following violation were observed. 184C is complied. 9-305B. Landscape at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover, including the swell area. Violation 9-280H1. The fence at this property is in disrepair, including but not limited to the bent portion abutting the north property line. It is not being maintained as required. A notice of hearing was posted on property on September 16, 2021, and a pre-hearing inspection was conducted on September 24, 2021, revealed the violations remains as depicted in the photos. The city is requesting 35 days to correct the violation or a fine of $50 for each violation day after.
So ordered.
Our next case is on page 15. Inspector Bover-Xantis, case number CE 210600283. Case address 1704 Northwest 9th Street. Owner Spirit of Jesus Deliverance Center, Inc. Property posted 9/9/21. Posted at City Hall 9/16/21.
Good afternoon, Your Honor. Case and address as read. Property was first inspected on June 10th, 2021. Violation were observed. 18-12A, there is overgrowth, trash, rubbish, and debris on this property, and its swell, including but not limited to wood pallets. violation 9-280H1. The chain link fence at this property is in disrepair and is not being maintained as required. There are missing parts of the fence. A notice of hearing was posted on property on September 9th, 2021, and a pre-hearing inspection was conducted on September 24th, 2021, revealed as depicted in the photos. The city is requesting 35 days to correct or a fine of $50 per violation for each day thereafter.
Ordered.
Our next case is on page 20. Case number CE 2012078. Case address 3130 Southwest 22nd Court. Owner Nasa Corrales Acuna and Alex Lanuza Acuna and all others. The city is requesting to vacate the order of April 13, 2021.
So ordered.
Our next case is on page 33. Case number CE 2011048. Case address 3001 North Ocean Boulevard. Owner 3001 North Ocean LLC. This case was first heard on 4/29/21 to comply by 5/9/2021 and 6/10/21. Suspended 6/24/21 and 8/27/21. Two sections complied at $50 per day. $2,200 accrued, and the city is requesting administrative cost of $810. $810.
Okay, so ordered.
Our next case on page 25, case number CE 2104037, case address 1916 Southwest 11th Street, owner MPG 1916 LLC. This property was cited on 7/15/21 to comply by 7/15/21. One section complied at $250 a day. The city is requesting full amount and no appeals received for this citation.
So ordered.
On page 25, case number CE On page 25, case number CE 200800189 is being rescheduled. Our next case on page 26, case number CE 2102089, case address 646 Northwest 10 Terrace, owner Sukan Dorothy Lee. This case was first heard on 4/29/21 to comply by 5/9/21, suspended 7/29/21 to 8/5/21. Five sections complied at $25 per day. $9,175 accrued, and the city is requesting full amount.
So ordered.
Case number CE 201208997. Case address 408 Northwest 14 Terrace, owner Fort Lauderdale Community Redevelopment Agency. This case was first heard on 3/25/21 to comply by 5/27/21. Four sections not complied at $50 per day. $25,000 accrued. The city is requesting full amount, and fines continue to accrue.
So ordered.
On page 27, case number CE 2012177. 1077 is being rescheduled. Our next case on page 28, case number CE 2105040, case address 831 Northwest 8th Avenue, owner Matali Inc. This case was first heard on 7/29/21 to comply by 8/19/21. One section not complied at $50 per day, $2,050 accrued. The city is requesting full amount, and fines continue to accrue.
So ordered.
On page 28, case number CE 200903666, case address 501 Orton Avenue, owner Grand Palm Plaza LLC. This case was first heard on 4/29/21 to comply by 5/13/21. Suspended 6/24/21 to 7/8/21. One section not complied at $50 per day, $6,200 accrued. The city is requesting full amount, and fines continue to accrue.
So ordered.
On page 29, case number CE 21030-350, case address 209 North Fort Lauderdale Beach Boulevard 2B, owner 209 North Fort Lauderdale Beach LLC. The city is requesting to vacate the order of May 11th, 2021.
So ordered.
Case number CE 21040-212, case address 1151 North Fort Lauderdale Beach Boulevard, owner Park Tower Association. The city is requesting to vacate the order of May 27, 2021.
So ordered.
Case number CE 21040-213, case address 3350 Northeast 14th Court, owner Camacho Family LLP. The city is requesting to vacate the order of May 27, 2021.
So ordered.
Case number CE 21040-214, case address 1415 North Fort Lauderdale Beach Boulevard, owner Iqbal Panjwani and Shamasha Panjwani. The city is requesting to vacate the order of May 27, 2021.
So ordered.
Case number CE 2103034, case address 551 North Fort Lauderdale Beach Boulevard, number R304. Owner Conrad PCC 304 LLC. The city is requesting to vacate the order of May 27, 2021.
So ordered.
On page 30, case number CE 2103035, case address 609 North Fort Lauderdale Beach Boulevard, CU-4. Owner Atlantic Hotel Group Assets LLC. The city is requesting to vacate the order of May 27, 2021.
So ordered.
Our next case on page 32. Case number CE 210400403, case address 1525 Northwest 18th Court. Owner Lai Chu Lung and all others in care of David Zimmerman. This case was first heard on 6/24/21 to comply by 8/26/21. Two sections not complied at $50 per day. $3,400 accrued. The city is requesting full amount fines continue to accrue.
So ordered.
On page 32, case number CE 20071231, case address 1401 Northwest 12th Street, owner Alejandro Ernesto Rodriguez. Case first heard 2/25/21 to comply by 4/29/21, suspended 6/24/21 to 7/2/21. One section not complied at $50 per day. $7,250 accrued. The city is requesting full amount fines continue to accrue.
So ordered.
On page 33, case number CE 210400054, case address 1556 Northwest 10th Place, owner IAG Foundation, Inc. This case was first heard on 7/29/21 to comply by 8/12/21. One section not complied at $50 per day. $2,400 accrued. The city is requesting full amount fines continue to accrue.
So ordered.
On page 33, case number CE 2105064, case address 930 Southwest 20th Street, owner Ballard Talek. The city is requesting to vacate the order of August 26, 2021.
So ordered.
On page 34, for case number CE 2105065, case address 2409 Northeast 22nd Terrace, owner Gary Rubenstein. The city is requesting to vacate the order of July 29, 2021.
So ordered.
On page 34, case number CE 210070765, this citation has been rescheduled. On page 35, case number CE 210400486, case address 1427 North Fort Lauderdale Beach Boulevard, owner Nick Davis and Sergio Morentis Ortiz. The city is requesting to vacate the order of May 27, 2021.
So ordered.
Case number CE 210400490, case address 1531 North Fort Lauderdale Beach Boulevard, owner KC Cross, 2012 Cross Trust. The city is requesting to vacate the order of May 27, 2021.
So ordered.
On page 37, case number CE 210700257, case address 127 Northeast 17th Avenue, owner Victoria Oaks LLC. This property was cited on 7/9/21 to comply by 7/9/21. One section complied at $400 per day. The city is requesting full amount and no appeals was received for this citation.
Okay, so ordered.
On page 38, case number CE 210100347, case address 1415 Southwest 1st Street, numbers 1 through 8, owner Modest Nook LLC, Inspector Gustavo Caracas. This case was first heard on 3/25/21 to comply by 4/29/21, suspended 6/24/21 to 7/29/21. One section complied at $100 per day, $10,900 accrued.
Your Honor.
Yes.
Good afternoon, Your Honor. I'm going to read the case because we finally got compliance on this particular case, ma'am, if you allow me to.
Okay.
Thank you, Your Honor. Good afternoon, Your Honor. Case and address number as read on record. This case first came before Special Master on March 25th of 2021, where evidence was presented and the magistrate found for the city. These violations were first cited on January 11th of 2021, and a total of 13 re-inspections were performed. There were conversations by the phone and in person with the property management, and during these conversations, the status of the violation and corrective actions were discussed. We do have compliance, Your Honor. The city's position is the following, Your Honor, if you may. We would like to reduce the fines to $3,207. That's 1/3 of $10,900, Your Honor.
Okay, so ordered.
Thank you, Your Honor.
You're welcome.
On page 39, case number CE 1906-1768 has been rescheduled. The city is requesting to enter pages 41 and 42 into today's hearing as an exhibit. It is the city's list of complied, closed, withdrawn, and rescheduled cases.
So ordered.
This concludes this morning's special magistrate hearing. We will take a brief 5-minute recess, and then we will begin this special magistrate lien reduction hearing. Special Magistrate lien reduction hearing for September 30th, 2021. If you wish to speak at today's hearing, please stand and raise your right hand. Monique, please raise your right hand online. Thank you so very much. Do you swear and affirm to speak the truth at today's proceedings? Thank you. So our first case is on page 4. Case number 1824. I'm sorry, case number CE 18070181. Case address 1824 Southeast 23rd Avenue. Owner Alexandre Gingras. This case has a total lien value of $20,600 and city direct cost of $751.52, and the city is requesting $6,180.
Okay.
Monique, you can unmute yourself. Yes, we can hear you now. Oh,
Okay. Now you can?
yes.
Okay. Hi, Your Honor. Good afternoon. So as you read my statement representing the owners, a lot of events happened, and since they're not here, I mean, that's not their first house. They are from Canada, and they do not understand the process. And then Irma just came. They applied for the permit before the hurricane, and then the fence ended up being in a pool, and the contractor did not want to come back and fix it. So they tried to fix it themselves. They came back, and the permit expired, and they still try to get a hold of this contractor. And then the court case was created in the meantime. And by the time they did find another contractor, they keep telling him they're going to do it. But they were just back in Canada at the time, and this contractor was giving them the runaround because he was doing other jobs. And by the time he got to it, because they renewed the permit and they changed the contractor back in 2019, but it took almost a whole year before the new contractor gives the liability and have this permit actually active. And then as soon as they did the inspection, then they needed to have a revision done. And then an inspection was called and then finally passed. But all this was just a nightmare for the owners.
Okay.
Your Honor, can I ask a question if I may?
Sure.
Thank you. For the record, Ronald Montoya Hassan. Ma'am, is this their primary residence?
No, it's not. They live in Canada.
Okay, thank you.
Okay. Under the circumstances, I am going to reduce the fines to $4,800 and 60 days to pay. And I also want to alert everyone here that if I reduce the fine and it's not paid within the time that I order, then the fine goes back to the original time, okay? All right. Okay, do you understand?
Yes, I do. I do. I just think it's still expensive for everything that happened to them. I mean, they tried everything they could, and people just give them the runaround, and they're saying things that happened, that's supposed to happen, but they're not here, so they don't know.
It's unfortunate, but if you purchase property in this state, you have to comply with the laws, whether you live in the state or not. So
yeah,
I gave her.
I know.
That's it. All right. Thank you.
Okay. Thank you very much. Bye-bye.
Our next case is on page 5. Case number CE 200900408. Case address 2443 Bimini Lane. Owner Arnold Surchuk in care of Beta Screen Corp. This case has a total lien value of $58,500 and city direct cost of $529.32. And the city is requesting $17,550. This case has a total lien value of $58,500 and city direct cost of $529.32. And the city is requesting $17,550.
Can you help me? I can't understand that. Is it going to be reduced?
No, she was just saying the lien amount.
The lien, yeah, okay. Okay, I understand.
Okay, please state your name for the record. No, just state your name for the record, please.
Arnold Surchuk.
Okay, and why did it take so long to comply this property?
I didn't know there was a violation. The violation was originally cited September 10, 2020. I was not here. We were at the height of the pandemic. I was in New Jersey where I live and where I work. I never had notification that there was a violation of any kind. Mr. Garcia sent a violation notice to an empty house. He put a violation notice on the empty house, but I never saw it because I wasn't here. Mr. Garcia claims that he sent notification to my address, my business address in New Jersey. I never saw it. The building that I'm in has 5 tenants. And if he did send something, it's something that I never saw it because I would have acted on it right away. I have been a homeowner for 36 years here, same house, here in Fort Lauderdale. I've paid my taxes all these years. And with the permission of Your Honor, I would like to read something very important. It's called a summary of events. And I could give you a copy of it if you want. I brought a copy.
If you've already provided to the city, then I've reviewed it in the file.
No, this is something different. This is new. This is additional information.
Okay, I just need to make you and everyone else understand that I can't retry the case in lien reduction, okay? So notice issues, all of those other issues, I can't retry in this proceedings.
I understand.
No, you don't have, you can't understand unless you let me finish my thought. Okay? What you're here for is to tell me if there are mitigating factors that we should show leniency about. But I cannot retry all of the aspects of the case.
I'm not asking to retry.
Okay?
I just want to add information that's very vital. Why it went that way, because I had no knowledge that there was a violation. When I found out there was a violation, 8 months later, I acted on the violation, and the violation was that my boat wasn't washed. I had the boat washed, and then Mr. Garcia said he couldn't read the numbers on the boat, and there was only 4 days going for the trial, and I was still in New Jersey. I called my boat mechanic, and I had the new registration numbers put on. The boat is now in compliance. I acted as soon as I could, as fast as I could, knowing what the violation was. So with your permission, I would like to read, it's only 2 short pages. It's called Summary of Events. Senior Code Compliance Officer, Mr. Manny Garcia, took advantage of the pandemic that has killed more than 60,000 people in Florida to cite my boat on an elevator above the canal for not being in compliance with an intangible regulation for questionable motives. He claims he posted a notice of my unoccupied home on September 10.
Sir, this is information you've already told me, and I told you that I can't retry the case.
Let me go to one thing that you haven't seen before. It's right here.
Now,
It's
answer
only
answer a question for me. You said that when you did get notice, you waited 8 months to comply the case. Why was that?
I didn't get notice until 8 months. I never got notice. I had no notice of what the violation was. On May 7, Mr. Garcia sent me a notice, and it's called derelict. In the derelict notice, there was no mention of a boat wash. All the other things that are in this law, this code in Fort Lauderdale called derelict, do not apply. Also, according to...
Your Honor, if I could, and again, I apologize for interrupting, but Rana Montoya Hassan, Your Honor, the city does not cite vessels that just need to be washed. This was a derelict vessel. It was already found to be in violation. As Your Honor has repeatedly said, we are not here to rehear the case. The code is very specific for lien reduction and that we do not rehear the case.
Your Honor, with all due respects, I really can't understand what you're saying. Maybe someone can help me. I didn't understand what you just said. I have trouble hearing.
Well, she reiterated what I've been telling you is that I can't retry the case here. I can only consider mitigating circumstances that maybe have delayed you. And I'm happy to consider those circumstances, but I cannot retry the case and I cannot overturn the orders that went before me.
The boat has been, the violation notice has been removed. The boat is not in violation.
Yes, I know, but this was about a derelict vehicle.
Not a damaged vehicle.
Pardon me?
Derelict vessel.
Quote, a derelict vehicle, but it's not derelict. It never was.
It was already determined to be a derelict vessel in an earlier hearing that we're not supposed to rehear pursuant to city code under a lien reduction procedure.
Well, what I'm reading here is Black's Law Dictionary defines derelict as only on the sea. A vessel suspended from the shore could never be defined as derelict. The boat was never in anyone's way. It just needed a wash. I have photos. If you look at the records, the photos indicated that the boat needed a wash. And because of the pandemic, I wasn't here. All these things were happening, and I just couldn't do anything about it. I called a boat mechanic who I've known for years when I first got notice that there was something wrong, but I didn't know what was wrong. He went to the boat, he looked at it, everything is sound, and he told me that the boat seems to be fine, there's nothing wrong with it. But Mr. Garcia never told me, never sent me the information of derelict. As soon as I got the information, and that happened on May 7 with a trial going on May 11 with only 4 days to do anything. And I acted on it promptly. The boat was washed. The registration numbers went on it within days. I did everything possible to be in compliance. The fine of $250 a day is something that's incredible because I didn't do anything to deserve that type of punishment. I did everything possible as a homeowner of 36 years, paying my taxes all these years, never a problem. And I want to hold on to my home. I don't want my home taken from me. My home belongs to me, my estate, my children, my grandchildren.
Okay, thank you very much, sir. I'm going to reduce the fine to $8,500 with 60 days to pay.
Your Honor, with all due respect, the fine is, as I see it, is an invasion of my liberties. The fine, I think, is inappropriate. I want to challenge the fine. How do I go about doing that?
Okay, I can't give you legal advice, sir. I suggest you consult a lawyer.
I will consult a lawyer. And is there anything else you would like to know? Is there anything else I could show you?
No. If you've told me everything, that's, again, sir, you've got giving me any mitigating factors except that you were out of town, and I understand that, but people that own property here are required to follow the law.
I followed the law as soon as I found out what the law was. I didn't hesitate one day.
Okay.
I have to be told what the definition
This was
of
out of
derelict is.
compliance, sir, for 234 days, and I made my ruling, and you have 60 days to pay. Thank you.
Your Honor, I'm going to say something that maybe I shouldn't say right now. This is a gross injustice.
Well, I appreciate your feelings, sir, but that is my ruling.
I am not in agreement with that ruling. It's inconsiderate. It is inconsiderate.
Sir,
and it's a violation of my liberties.
Okay.
It's a violation of the Constitution.
So noted, sir.
Our next case is on page 3. Case number CE 21050567. Case address 1212 Northeast 18th Avenue. Owner Ralph Greenidge and Patricia Dowdy. This case has a total lien value of $7,800 and city direct cost of $247.98. And the city is requesting $3,900.
Okay, please state your name for the record.
Good afternoon, Your Honor. Patricia Dowdy.
Good afternoon.
And my name is Jan Stahl. I'm her property manager.
Okay, good afternoon.
Good afternoon.
Your Honor, this is my husband, Ralph Greenidge. He's a disabled veteran.
Nice to see you, sir. Okay, this property has a total lien amount of $7,800. City's requesting $3,900. What do you want to tell me?
What we've done is we got a notification when we got violation, let's try it again. When I got notified that it was not compiling to the VRBO.
Okay, can you speak into the
Yes,
microphone?
I'm sorry.
please?
When
That's okay.
let me take this. When we were notified that we were in violation of the vacation rental, I immediately contacted the city, filled out all the permits, paid all the licensing fees, and we were in compliance. They live in New York. They got a letter saying that they had to go to a hearing. Am I right?
No.
I'm sorry.
No. What happened is, I reside, Your Honor, at 1124 Northeast 18th Avenue, right down the street, and I take care of my mom, 97-year-old mom. And my husband went to New York by himself to get treatment, and apparently for some reason the mail went there.
Medical treatment?
Yes, at NYU. And for some reason, the mail went up there, so we missed the original hearing. But I originally bought this house for my daughter for when she retires, because I live right down the street. And that's why, what else do I want to say?
No, it's just and then her daughter didn't move down, so we decided to vacation rental it.
Okay.
And then we fixed up the property considerably. If you look at the pictures, they put, they totally rehabbed the property. That's why we send in pictures of before and after the property.
Okay,
So,
did you continue to advertise the property after you were told that you were in violation?
it stayed up there, but we put, right when that got notified, I compiled, like we did all the paperwork. We got it inspected. We had everything done. It was, we didn't know we had to go to a hearing. That it was, honestly, she never got the notice, and it was my fault possibly, is that I didn't know you had to go to a hearing if we already compiled with all the rules and regulations.
Okay, well, again, I can't hear about all of that. What I could consider is if, when your husband was in treatment in New York, did you say that the notices went up there?
The notice went to a Brooklyn address, and by the time he got the mail, the hearing was over. But I did, as soon as I found out what was going on, I called, and I also got a certificate of compliance. Took care of that right away, and also I had to put a new roof on, which cost me $30,000, and I have a receipt for that too.
Your Honor, if I could?
Yes.
Rhonda Montoya Hassan with the City Attorney's Office. Again, with this case, we're re-arguing issues that have gone by the wayside because there's already been a finding. But the notices would have gone and would continue to go to a P.O. box in Brooklyn, New York, because as well as the tax bill, because that's what's listed on BCPA. As Your Honor knows, the city also posts the property and posts at City Hall, just since we're rehashing old issues.
Okay, all right. Okay, and what are your circumstances now to pay the fine?
I would bill myself to the court, Your Honor, to reduce the fine.
I'm sorry, I can't hear you.
I would throw myself at the mercy of the court to reduce the amount of $7,800 to administrative cost or whatever.
Okay, all right. I'm going to reduce the fine to $1,500, and I can give you 90 days to pay.
Great.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you,
You're welcome. Good luck to you, sir.
Our next case is on page 2, case number CE 1801126, case address 730 Alabama Avenue, owner 1528 Brickoloft LLC. This case has a total lien value of $14,250 and city direct cost of $1,396, and the city is requesting $2,850. And also another case on the bottom of page 1. Case number CE 1812026, 730 Alabama Avenue, 1528 Brickoloft LLC owner. This case has a total lien value of $10,400 and city direct cost of $705.52. And the city is requesting $2,080.
Hello. Good afternoon, Your Honor. My name is Patrizia Sanino. The case, you have it, right? This property was bought on March 2020, and we started pulling the permitting, and the house went under very extensive rehab. We had a little bit of a problem with the contractor that was not pulling the correct permit. So we took over, and then we started doing everything correctly. So all the permits are being pulled. Now the house is in very good, I will say, shape. We have a picture of the actual condition of the house. We are going probably to complete the complete remodeling in another month. The roof was changed, and we had just to comply with this roof and trousers, $41,195.
Okay, am I correct that you purchased this property with the existing liens?
Yes, ma'am. The
Okay. Was
previous
anything escrowed from closing to pay the liens?
I'm sorry, ma'am.
Was anything escrowed from closing to pay the liens?
They say to comply first, and then when everything was in comply, we could request the lien reduction. That's what we were instructed by the city. And so we start pulling all the permit. We redid the entire trousers and the roof. And then we also did a house extension, pulling the permitting. And we are asking, please, if it's possible, to reduce the two liens for $2,000.
Okay. All right. Anything from the city? Did you want to chime in? Oh, okay. All right, I'm going to reduce both cases together, our total liens, I think, of $24,650. And I will reduce both to $4,500.
Okay.
With 60 days to pay.
Okay. Thank you, Your Honor.
You're welcome.
Our next case is on page 4, case number CE-19110997, case address 1931 Southwest 23rd Terrace, owner Acelia Allen and Russell Allen. This case has a total lien value of $28,100 and city direct cost of $979.84, and the city is requesting $7,025.
Good afternoon, Your Honor.
Good afternoon. Please state your name.
Acelia Allen.
Okay. And we have a total lien here, $28,100. It was out of compliance for 282 days. What do you want to tell me?
Yes, so in 2019, me and my ex-husband, we rented the property and separated with him. So we agreed that he's going to be maintaining the property and receiving mail. So I would.
Can you speak up a little?
I apologize. So my ex-husband, we agreed that my ex-husband will be maintaining the property and taking care of the mail. And I wasn't aware about this. I wasn't aware about fines, and when I moved back into the house, I received a letter from City of Fort Lauderdale and immediately contacted City of Fort Lauderdale. I spoke to Mary Alman and Monique Drake, and I complied immediately.
Is there a pending sale on the property?
No, I'm going to be keeping the house.
So are you homesteading the property?
I'm sorry?
Are you homesteading the property?
Oh, no. I'm just going to be
okay, all right.
Staying there.
Okay. I will reduce the fine to $2,800, 60 days to pay.
Appreciate it. Thank you.
Thank you.
Our next case is on page 1, case number CE-2007-0513, case address 101 Southwest 22nd Avenue, owner Apex Homes Group LLC. This case has a total lien value of $41,750 and city direct cost of $912.38, and the city is requesting $8,350.
Good afternoon, Your Honor.
Good afternoon.
If I may, let me just give you a little bit of a background as to what happened.
Okay.
So this is our first investment property. When we bought it back in May of last year, we used hard money to buy the house because getting approved on a conventional mortgage at that time was not possible because of the very poor condition of the house and the uncertainty of the COVID-19. They're just not, approving loans that fast. The roof was leaking. They did not have hot water for 8 years. The stove was taking at almost an hour to heat up. The back door glass was broken due to one of the storms, and it was just held by duct tape. And there was just a few problems of the house. I mean, all in all, a family with two kids were living for me in an uninhabitable condition. And our intentions were to fix the basic problems and bring the house into a decent, livable condition so that we can rent it and have some income coming in for our family. However, after 2 weeks of owning the property, the roof caved in, so we had to replace the roof. Then we tried to give them the hot water, then it became a big plumbing issue. Then we tried to fix that stove, and it became a big electrical issue. The electrician even told us that he was surprised that the roof has not burned down because of exposed wires. Having kids myself, I know that, a broken door is a very a hazard to everybody who's living in that house. And so we ended up replacing the door so that we removed that broken glass, and it is the most cost-effective way for us to, address the problem. As we work through the house, we discovered lots of roaches and ants in the house, and then as they pulled the roof, we saw rat droppings. So all in all, we were not intending to do major repairs on the house because we can't afford it. Our intent is to do the basic repair. But as we encountered these issues, we were left with no choice but to do the work so that whoever lives in that house is safe. Our intentions were good. Our problem was that we did not really know that there is a process that we need to follow to bring this house into a decent, livable condition. And to date, all the citations we have addressed, everything is passed. The only outstanding item for us is the plumbing. The last request was for us to give a letter, to get a letter from the engineer, and we got that letter finally
Okay.
3 weeks ago.
Yeah, okay. As far as I know, what's before me was eventually complied.
Yes, everything is compliant.
Yes. Now, I read in the file that there was a financial hardship. Did that
Yes.
delay the problems?
Yes, because our budget was really 20,000 really to fix up those little things. But as you can see in the numbers there, we ended up doing a major repair to the house because of just the very poor condition. And we have to borrow to our 401k, our children's school or education that we set aside. We have to borrow, and right now everything that we have is in that house. We cannot let it go, because if we let it go, all our financial will be just down the drain. So we're doing whatever we can so that at least something will come back to us to pay off whatever we can pay off.
Okay, so you got loans and you maxed out your credit cards to try to get it done? Yes. Okay. All right, I see that you offered $2,500 and the city wants $8,350 with the mitigating circumstance, et cetera. I will reduce the lien to $3,500 with 90 days to pay.
Thank you very much.
Thank you.
Our next case is on page 2, Case number CE 18052123. Case address 807 Northeast 4th Avenue, owner FCM 807 LLC. This case has a total lien value of $44,850 and city direct cost of $1,167.92, and the city is requesting $22,425.
Good afternoon, how are you?
Okay.
My name is Chaim Kahani. This is a commercial investment property. We had leased the space that was cited for a violation to a tenant a couple of years ago. The inspector, when he cited the violation, we had told him that the tenant was not to be using it as a retail use as per the lease agreement. We spoke to the tenant at that time, asked them to make sure they were not using it as a retail use, which they said they were not. We had scheduled for the inspector to come do a reinspection of the property. At that point, he had actually canceled it. And at that point, the violation, in our mind, actually just honestly got forgotten about. It's resurfaced when we went into a contract to sell the property, which has now closed. When we were notified about the violation, we moved quickly to remediate it, which we did within 30
Are
days.
you representing the new owner or are you the old owner?
I'm the old owner.
Okay, all right. And the price, the property sold for 1.85 million?
Correct.
Okay. And the property was out of compliance for 1,193 days?
It's because we didn't know that the violation still existed. When we found out that the violation existed, when we ran a lien report, when the property went to contract to be sold, we had the violation cured within 30 days.
Okay, and
as per our leases, the tenants are usually required to rectify any violations that come up. But the tenant vacated the property due to COVID.
see, but I cannot retry the case.
I understand.
I cannot deal with, when you got notice and when you didn't get notice. And, under the circumstances, was money escrowed from the sale of the house to pay these fees?
Yes.
The lien?
Yes.
Okay, all right. All right, I'm going to grant the city's request for $22,425 with 60 days to pay.
Okay, thank you.
Our next case is on page 3. Case number CE 19030639. Case address 1762 North Federal Highway, owner Bal Harbor Square LLC. This case has a total lien value of $6,900 and city direct cost of $911.36, and the city is requesting $3,450.
Okay, please state your name.
Good afternoon, Your Honor. Andrew Shine with Lockery and Chakas, representing the property owner. Just to preface, it's my understanding that the purpose of code compliance is compliance and not punishment. And in this case, they were working towards compliance the entire time. They had contractors that disappeared, came back, and they were updating the special magistrate almost throughout the entire time on this. So I don't believe that it's necessary to go beyond administrative costs in this case, as they were working towards compliance, and it wasn't something that they could fix on their own, like overgrowth or dead or missing ground cover. It was a fairly large buffer wall that needed to be professionally done. So they were working towards compliance the entire time, and I think administrative costs would be appropriate in this case.
Okay, I will reduce the fine to $2,500 with 60 days to pay. Thank you.
Thank you.
Our next case is on page 5. Case number CE 14030038. Case address 2790 Southwest 3rd Street. Owner, Almedina Investments LLC trustee. This case has a total lien value of $181,100 and administrative cost of $654.46. The city is requesting $18,110.
Okay, please state your name for the record.
Tawana Holmes.
Okay, what do you want to tell me about this property?
The property was purchased with the liens.
I
in
can't
place.
hear you
The
now.
property was purchased with the liens in place, so we were just looking for a reduced figure to pay it off, now that it's in compliance.
Okay. So you're the new owner?
I am not. I'm the agent for the owner.
I'm sorry.
I'm the agent for the owner.
Okay, for the new owner?
Yes, the new owner.
Okay. And did they purchase the property with the liens already?
Yes.
Okay. Did they comply the property, or did the old owner comply the property?
The new owner complied.
The new owner complied?
Yes, there was a carport built without a permit that he removed. And the windows, he obtained a permit and repaired them and closed out that permit as well.
Okay. All right, I will reduce the fines to 7,000 with 60 days to pay.
Thank you. Would I get that today? Something in writing today? Okay, thank you.
Our next case is on page 3. Case number CE 21050526, case address 1505 Northeast 5th Street, owners Sean and Kirsten Malloy. This case has a total lien value of $7,400 and city direct cost of $288.84, and the city is requesting $3,700.
Hello, Your Honor.
Hello.
My name is Kirsten Malloy,
Okay.
and I'm the owner with my husband. And I'm asking for some financial leniency because when COVID hit, my husband and I were small business owners in a marketing promotions business that basically stopped overnight. And it's our only house. It's our principal main residence. And to keep the home and not lose it, since we had lost our business, we put it up on VRBO, and we had no idea that we had to, VRBO said that they pay the taxes, and, we were just totally ignorant to everything that had to be done. And my husband ended up getting a job in construction at, the age of 60 years old, starting a new career just to make ends meet. I started cleaning houses, and we did everything that we could. We rented a 660 square foot apartment. It was not our intention to be living this way, but, we got hit. And as soon as we got the notice from the city, we acted as quickly as we could. We had to deal with the state, the county, the city, everything's online. We asked the city if we could have an extension or some more help to get this done, because we couldn't do it in 5 days. By the time we saw the notice, 2 or 3 days had already gone by. And, I'm a law-abiding citizen. I've never not complied with the law, and I'm a very respectful person, and I'm just asking for some leniency. We're struggling enough to keep the home. We take very good care of it, and,
All right, I'm going to reduce to the city cost of $288.84.
Thank you very much.
You're welcome. Good luck to you. I hope things get better.
Thank you.
Oh, 60 days to pay.
Thank you. So will I get a notice?
Our next case on page 3, case number CE 21050448, case address 1236 Northeast 18th Avenue, owner Shari Steer. This case has a total lien value of $6,800 and administrative cost of $293.98, and the city is requesting $3,400.
Good morning, Your Honor. Thank you for having us today. My name is Jessie. This is my mom, Sherry. I help manage her vacation rental. I've submitted the application, but I just wanted to start by saying we respect the city of Fort Lauderdale and have every intention of being in compliance to do business in good standing. I help
Speak
manage.
into the microphone, please.
Sorry. I help manage my mother's vacation rental, and I would like to mention it's currently in good standing with all its proper licenses. This was our first vacation rental, and my mom has been willing to pay any fee and do everything required by the city and state to get proper licensing. She trusted me to handle this and direct her. The property was purchased with an active vacation rental license. When it came time, obviously we reapplied. When it came time for the inspection, everything required by the inspection was present, since it's passed inspection before. The only issue was that the pool door sensors, they lose battery very quickly. They ran out of, I guess, battery, and some of the smoke detectors batteries were also bad. Everything needed for the inspection was present. And then although the batteries were bad, we did have backup security measures in place. We paid Bring Smart Home Security System, which does have its own pool sensors that are in working condition and have its own set of smoke detectors. Also, when the inspector came and he saw the batteries, he said, everything's good, just, get the batteries fixed and call me back for inspection. I was not aware that he never told me that we officially failed inspection. That's why we also never had to pay for a reinspection fee, and I didn't, I just honestly didn't call him back in time for a new inspection. But I submitted proof that I did order the new sensors right away on Amazon. And it's not my mother's intention to not be in compliance. She's done everything asked of her. We are asking for leniency with the city for reduction to only administrative costs, please. Thank you for your time, Your Honor.
All right. I will reduce the fine to $1,400 with 60 days to pay.
Thank you, Your Honor.
Thank you. Thank you.
Our next case is on page 1. Case number CE 21010478, case address 11 Sylvan Lane, owner Next January Holdings LLC. This case has a total lien value of $7,000 and administrative costs of $442.66, and the city is requesting $3,500.
Hi, how are you?
Good.
Zachary
Please state your
Cormichael.
name.
Zachary Cormichael.
Okay. And what do you want to tell me as to why this property was not brought into compliance?
Well, I had the property rented to a 30-day tenant, and then can you hear me okay, or?
Yeah.
Okay.
Yeah, just turn the mic up a little. I'm having trouble hearing out of that mic today.
Then I had spoken to Monique, and she said, well, it's not so much about the tenant, it was more so about the advertising that you had in place. But I didn't actually have advertising in place. I bought it from a prior Airbnb host or owner, and it was her ad that was being run by a property management company, which I just provided. I don't know if you got those, the text screenshot showing me texting him saying, hey, I need you to take this down because it's creating confusion.
Unfortunately, that happens a lot in these kinds of cases. And, if you own the property, you're responsible, even though someone else may have posted the ad.
Yeah, but how would you know, though, I guess?
But you did rent the property out for 30 days at $1,266 a night. Was that after you knew that property wasn't in compliance?
This was before, so that lease was prior to, and that was a direct booking that I did, just myself.
And did you...
I have another property right in front of this one that's of course registered, and so I pick up some traffic from that, and I had a direct booking from that.
Okay, and when you found out about the property, did you rent it at all after that, before?
No, just the first tenant that I had was that 30-day booking, so I had renovated the property because we had a big mold issue, booked it to him, and then my intention was, while he was there, was to register the property, which I did and I provided, and I have him here right now. I was already in the process of registering the property when I received the violation notice. So the day that I got it, I messaged the Camille, letting her know, hey, I also got this notice. I just want to make sure that everybody knows that I'm doing what I'm supposed to, that everybody internally is talking to one another. And she said, don't worry about it, you're good, and that was it.
Okay. All right, I'll reduce the fine to $1,500 with 60 days to pay.
Okay. I appreciate it.
Thank you.
Thank you.
This concludes the special magistrate hearing for September 30th, 2021.
Happy day. Have a good afternoon, everyone.